That's the inclusion and upgradation, my lord. The fact remains on the last petition, your lordship was pleased to February under the same heading, my lord. But somehow it has appeared in the list of
maybe I have interpreted it wrongly because mentioned matters will come under mentioned matters heading only on the first day.
Matter is very urgent, my lord. Kindly check the matter.
Please wait for your turn. On the days list, please.
My lord, under compelling circumstances, my lord, I am mentioning on matter which is
content application, my lord. Content.
My
lord, it was mentioned before. It was filed on 18th October 2023. It was first mentioned on, my lord, 11th December. File is lying in the RT. Petition to be sent to the RT department.
only one.
May I be permitted to mention?
Order, your lordship.
I have called the days list, sir. I'm sorry. You have to wait for your turn.
Already constructed.
Item number 1. Who is appearing?
I am for respondent number 4 and applicant. I am for respondent number 4 and applicant.
What is the application about?
For dismissal of the writ petition. It's a long pending, no steps taken, and this is the finance company's agreement. It was vehicle was seized, and they challenged the virus of section 51 of Motor Vehicles Act.
Mr. Banerjee, you are the petitioner.
I am for the state in this matter.
On the last occasion, Mr. Banerjee and me was there. Petitioner not there.
Not appear on the last occasion.
Appearing.
Well, earlier it is of 2008 matter.
2008. Old matter.
This is a group 7 matter.
Group 7
Group
matter.
7, motor vehicles. In the form, they have written group 9 wrongly.
Notice it.
But section 51 of the Motor Vehicles Act has been challenged.
Mention করেছি আমরা group 7 last
I am told that twice notice has been served by the private.
Yes, we have served notices. That was not.
the last
Notice to this.
এটা বেশি দিয়ে যাচ্ছে
Notice to the mentioning a notice to the
the matter was placed before the Lok Adalat, then again sent back to the court.
The petition did not turn up, even Lok Adalat.
So let it be dismissed.
My lord.
None appears for the petitioner, no accommodation is sought. Dismiss for default, full order to Corbin. The connected application is also dismissed.
My lord, that can be disposed of in view of dismissal of them.
It's your
This is my application.
Oh.
Yes, my application.
Join the connected application disposed of.
Grateful.
But this is a restoration application, and there is also delay.
Sir,
Yes, I have served. This is not affidavit service.
you are appearing for the state?
I am for the respondent number 7.
Why 2 applications?
The one is section 5 and kindly condone the data. An advocate, he could not. There is change.
Initially, the copy was not served upon the respondent, perhaps.
No, I have served.
Are you objecting to this? Are you objecting to the rest?
No.
Are we ready with the writ petition?
But it can be taken up any day. Today, ready today. Today, I am not ready.
Can 1 or can 2? Actually, affidavit of service. The applicant petitioner has prayed for condonation of delay in filing the restoration application. Paragraph, good grounds being shown. The delay in filing the restoration application is condoned. Paragraph.
Next week, any day, subject to your lordship's kind convenience.
Petitioner the applicant petitioners also pray for restoration of the writ petition which was dismissed for default by an order passed on 21st September 2022. Paragraph, sufficient grounds being made out, the application is allowed. The order passed on 21st September 2022 is set aside. Paragraph, the writ petition is restored to its original file and number. Paragraph, can 1 of 2023 and 2 of 2023 are disposed of, urgent certified website.
Let it appear in the next month. This will appear in the next month. This month.
Next monthly list.
Yes, madam.
WPA on prayer of the petitioners, let the matter appear under the heading motion.
Marshal.
In the monthly list of March,
March, yes.
March 2024.
That one thing, Lord, I have deposited deficit court fees. There are more than one petition. Let it be recorded, Lord.
In this matter,
Yes, yes, in this matter.
শুরুতে একটা লাইন করে দিন, deficit court fees deposited by the applicant petitioners is taken on record.
Obliged, Lord, deeply obliged.
Copy of
Deeply obliged. তাহলে কি কপি একটা লাগবে?
দিতে হবে, copy of the receipt showing, হ্যাঁ,
এই দাদা একটা কপি মেন পিটিশন একটা কপি
the deficit court fees is in the application or the writ
in
petition.
the read petition. More than one petitioner have
Petitioner. Next,
obliged. And I am for the petition. As per the order of the footman, I have served contempt notice.
have you served?
Yes, I have served. But I received page number 21, madam. What was the order? The 11% 22, second paragraph, madam. In the premises, the court is inclined to hold that since the demarcation of the disputed plot in using process, in the event encroachment upon the PW land or any portion thereof is found upon demarcation, the Assistant Engineer is directed to initiate proceeding under Section 10 of the West Bengal Highways Act and take the proceeding to its logical conclusion within 3 months from the date of the communication of the order upon according reasonable opportunity hearing to all the interested parties, including the petitioner and private establishment. Well, thereafter, my lord,
Who is the assistant engineer?
Assistant Engineer, my lord,
Respondent number 5.
5, my lord. Next, my lord,
Have you served him by name?
page 28.
What is his name?
Name, my lord.
Probit Chakraborty.
Yes, my lord. Probit Chakraborty. Thereafter, my lord, hardware petitioner, my lord, order was passed. Kindly see, my lord, page 28.
Page 28 of the writ petition.
Yes, no, my lord, contempt application. Contempt application.
Contempt application. Give me a minute, please. I just check the service. I think you have to make a fresh service. This item has been delivered to the PWD Roads article receipt room. The contemptor may not be aware.
It's not there, my lord, I have served. By name,
PWD
sir.
Roads article receipt room.
My lord, kindly is delivered, confirmed. Top portion, my lord, right hand side.
Yes, what is the address that you've given?
My lord, address, my lord.
It's Boshirhat HO.
Yes, my lord. Address correct, correct.
How can that be the address of the contender? How can that be the complete address of the contender?
My lord, he is holding post assistant engineer, my lord, public roads department, Bosirat Highway subdivision, post office Bosirat, police station Bosirat.
Where is the entire address in the postal receipt?
My lord, postal receipt, my lord, kindly see, my lord. Page 5 of the.
Why don't you make another service? Since this is a contempt application, I will be issuing rule. Because item delivered to PWD Roads article receipt room. Please see the track report.
Postal, my lord.
It's difficult. Will you please make another service and come back?
Yes.
Since it's a contempt application, it's a serious matter. The person should know that it has been sent. Affidavit of service filed by the applicant petitioner is taken on record. None appears for the alleged contender. Paragraph, it appears that service has been made at PWD Roads, bracketed article receipt room. Article receipt room. It appears from the track report. Paragraph, the applicant petitioner is directed to serve a further notice upon the alleged contemner, intimating the adjourned date and submit affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 14th March.
March.
Should be sufficient. Room. Next.
My lord, I appear for the alleged contempt. The order has been complied.
Compliant? Your
My lord.
affidavit of compliance,
This is the affidavit of service. It may kindly be kept on the
has
record.
it been complied with?
Purportedly complied, but I let
This is the order. I shall file my affidavit.
Affidavit.
kindly, my
I
lord,
shall file. I shall-
the order, some typographical mistake is there.
Yes.
The order should be 4/10/2023.
410. There is a typographical mistake.
Mistake is there. Actually, my client got it yesterday. They were sitting on the fence waiting for the result. After receiving it, they could have sent it earlier even. And another thing, your lordship, though I must make clear some means the deputy secretary KMDA, the nomenclature, it should have been according to me. I am just bringing it to your lordship's notice. It should have been deputy secretary, estate M and M unit KMDA, because your lordship in the writ jurisdiction has directed specifically to her, to the deputy secretary,
The fourth respondent.
the fourth respondent. So in this contempt petition, I can only bring it to your lordship and it is between you and
And it has to be complied with by the fourth respondent,
yes.
Yes.
not by anyone else.
Yes.
No. Fourth respondent has complied with, and lordship will find the notice annexed with the copy, my lord. I have.
It is not the notice.
There mentioned, my lord, estate MM, but
Yes.
in the order, I find the deputy secretary
So
often.
make Mr. Taluka, make the necessary corrections, please.
And let
And
answer-
Yes.
An affidavit of
Yes,
compliance.
and the order will be served afresh. Yes, I will do that.
Oh, no.
Affidavit of service. Paragraph, learned counsel for the
Not.
alleged contemner submits that the order under contempt has been complied with. Learned counsel seeks to submit affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on
My lord,
7th March.
7 March or next Thursday, my lord. It is just
Next Thursday, give out.
29th.
7th March is a short date.
Short day.
But I don't have any. I cannot say anything, my lord.
Come back on 7th March. Because he has to be ready, he has to make a correction and come back.
Yes.
As your
Next month,
I can,
affidavit of compliance we submitted on the adjourned date.
but your lordship, at least the order is purportedly
Can we-
complied.
My lord, can we correct this order typographical mistake and
Since I'm not recording it, I've
yes.
just recorded that you have complied. You say that you have complied.
So we can make
The
we
proper
can
order.
make necessary correction in the order. Much.
Proper-
Well, it will come on 7th March.
7th March.
At that time, I shall be given a fresh.
Yes. You will be served with a copy of the affidavit of compliance.
Deep law.
I shall file it.
Well, I am appealing item number 5, madam. This is the new content, madam.
Will you serve and come back?
Yes. New
Please.
content I have not start. I have to
Please
start.
serve and come back. The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 21st March.
For the petitioner. In this matter, my learned senior Vivek Dibasu is appearing for the petitioner. Due to illness, he has not come to court today, my lord. So I am paying for not today and not tomorrow.
17 matters, sir. Please make your submission.
Madam, earlier question matter was taken up by your lordship,
Yes.
and your lordship granted leave to add as party
Is
respondent.
appearing for the respondents. A report was called for. Are you ready with the report?
Also paid for 2 weeks time because the forest department is newly added to the report. I already completed the forest department for time.
So please come back with the report.
Well, leave may be granted to add forest divisional forest officer as party respondent.
That is added, yes.
That
it is
is-
added.
I have not added. I have come, but your lordship, your officer did not allow me to add as party respondent. On that day, I was not appeared, but on the next day, I came.
How can you be allowed on the next day, sir? It has to be done on the same day.
On the same date, I was not here, madam.
Cost item.
Only correction of cost item, madam.
That has to be done on the date. You cannot just ask for
On
the
that
record
day, I
to
was
be-
not appeared, madam.
Blame my officers like this.
No, on that day, I was not appeared due to my
That's my officer's fault.
no, that is not.
Why are you blaming the officers unnecessarily? Please do not do this. You cannot come on the next day and ask for a correction of a previous day's record. That is not permissible at all. You can do it today.
Listen, madam.
Learned Counsel for the respondents seeks extension of time to submit the report in the form of affidavit along with relevant documents as sought. With regard to utilization, a paragraph, let the matter appear under the same heading on 18th March. Please serve an advance copy. Mr. Mohan.
Grateful.
Next.
My lord, in this matter, my lord, I beg to appear for the petitioner, my lord. Mrs. Usha Maiti is on the earlier question is leading me through online. My lord, what happened? Currently, my lord, the
Where is the
Kolkata Met.
report of the KMDA who
Yes, yes. My lord, Kolkata Metropolitan Development Authority. Now, my lord, has given report. My lord, on 15th February, they have sent that report through, my lord, the WhatsApp at about 10 p.m. Now, at present, my lord, they have handed over this. My lord, we want, my lord, 2 weeks time for, my lord,
Exception?
exception.
Where is the report?
Yes, my lord. This is
Please
the
file.
copy of
Yes.
I'm led by Mr.
Only 2
Fadl
weeks time.
Bakmal.
আমাকে কপি দে
আপনাকে স্যার
হ্যাঁ তোর স্ট্যান্ড কি আমার সেটার উপর তো নির্ভর করে
এই তো দিচ্ছি
A report in the form of affidavit submitted on behalf of the KMDA is taken on record. Paragraph, on prayer of the petitioner, liberty is granted to use an exception to the report. Paragraph, let the matter appear under the same heading on 20th March.
20th March. At the top, my lord. At the top.
If all the matters are at the
Yes, yes, sir.
top. Entire list is at the top.
Yes, yes.
Next.
I'm grateful.
I'm appearing for 18. I am appearing for the petitioners, my lord. I got the copy of the report. My lord, I kindly allow me to grant me 10 days time to file exception.
Your lordship direct to file report, Warrant, Railway Authority, we are kindly accept this one.
5460. These matters are going on for
Yes.
several days. They need to be disposed of now.
My lord, I shall. 3-4 occasions, my lord, time sought for by the rail authority to
This is the railways report. The state has filed a report.
state or long back state
State
filed the
has already
report.
filed long back. Yes.
My lord.
This is the railways report. This is the matter where there is a dispute between the state and the railway.
No, ma'am. Petitioner and the railway.
Petitioners land with the
Railway
railway
Authority.
authority. We are claiming that it is our land, railway.
Your lordship is correct, man. And because my lord.
In the demarcation, there was a dispute. There was a-
That is the problem.
I remember.
Yes.
You want to use an exception?
My lord, short exceptional and
Report in the form of affidavit submitted on behalf of the railway authority is taken on record. Paragraph, on prayer of the petitioners, liberty is granted to use an exception to the report. Paragraph, let the matter appear under the same heading on 21st March.
24.
Please be ready for the hearing.
My
on
lord,
that.
my lord.
Several dates
Very
have gone.
short point, my lord.
Very short point, but several dates have gone.
Demarcation is acceptable to all the parties or not, my lord. That is the point. Nothing else. 8 to 18, my lord.
8 to 8.
8 to 18.
It's all together. with
My-
Item 19.
এটা এইগুলোকে আমরা appeal করি।
Item 19.
18 এ আমরা
And the state respondent, my lord.
Is appearing 19.
Kalyan Sengupta.
Item 19.
My lord, it is challenge the virus.
Yes.
Virus.
None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the same heading in the monthly list of March 2024.
Okay.
2021, 22.
Item 20.
It's wrong today. You, that's what you.
Appear for the respondents in this matter.
Regular মামলা হবে না।
মানে 17 সালের মামলা করবে না
Yes, anyone for the petitioner?
তাই তো খালি মেনশনিং করে
On the earlier occasions also no one appeared. None appears for the petitioner. No accommodation is sought. Dismissed for default.
2021 and 22, same.
It's together. All three of them are together.
Yes, yes.
On the earlier occasion also no one appeared.
No one appeared.
They are not interested in further.
23.
17, 18 সব একই কেস কেউ করবে না
Petitioner?
দাদা
Who is appearing for the state, Mr. Banerjee? Oran Banerjee. Where is Mr. Oran Banerjee? No one for any party. None appears for the parties. Let the matter appear under the same heading in the monthly list of March 2024.
Five.
My lord, from in item number 25 to 29, my lord, Mr. Ujjwal Rai is appearing, my lord, for the petitioner, my lord.
Yes.
Humbly pray for a Passover.
Yes.
25.
25, my lord. 25 to 29, all of my lords, analogous matters, my lord.
5 to 29
Lord,
Please make your submission.
yes, my
Otherwise,
lord.
I'll dismiss them.
My lord.
There are occasions where the petitioner has not cared to appear.
Sorry, my lord, I was on making code number 11.
You are appearing for the petitioner?
Petitioner.
Yes.
My lord, matters, my lord, which are before your lordships, are, my lord, pertains to, my lord, the enemy properties. My lord has seen that. Now, my lord, lordship will kindly see the earlier order. I am telling your lordship the date of the order. All these matters, my lord, were taken up together by my lord Justice Banerjee. When, my lord, an interim order, my lord, was passed. Now, my lord, among these 9 matters, when taken up together by my lord Justice Banerjee, the interim order that let there be no further, my lord, changes in the record of rights or, my lord, as to the status of the property be made till the disposal. These 5 matters before your lordship are one of those 9 matters, are 5 of those 9 matters. So, my lord, 2 matters.
Other 4 matters.
That is the difficulty, my lord, I'm placing to your lordship. The other 2 matters, which are still, my lord Justice Banerjee, my lord, is insisting of these matters, while my lord sits singly. Because, my lord, there is contempt also, my lord, pending, my lord, against the respondents. My lord, Arijit Banerjee. While my lord sits singly. If I can hand up.
These matters are also placed before him. There'll be a conflict
Lordship will kindly.
otherwise.
My lord, lordship will kindly seize these orders before my lord Justice Banerjee. একবার জজ সাহেবকে দেখান my lord, the last order 20th of January 2023 and lordship the previous order lordship sees no the last of the lordship. So, my lord, these 2 matters, whenever my lord sits singly, are, my lord, taken up.
So let me release these matters to be taken up by the same bench. There will be conflict of decisions otherwise. 9 similar matters, 5 are here, 2 before the other bench and the other 2.
My lord,
You say 9 matters.
my lord, there are 4 matters before my lord Justice Banerjee. My lord, this is what is the difficulty, my lord, you are facing.
Determination. कौन Banerjee?
What do you mean?
Justice.
That is a different.
The division bench.
No, division.
No,
When
no,
sits
single
singly.
bench orders are there.
So let us have a look at the orders because unnecessarily this
Now, my lord, order was passed, my lord.
No, no, no. Even now, when he's sitting singly, he's passing orders. 2023 also he has passed orders.
It is also, my lord, written that whenever lordship sits singly, the matter will be again taken up.
It is recorded that whenever the court sits singly, it will be taken up. So, senior bench, I have to release. I'll release the matters. Let it be.
But my lord, I suppose, my lord, are these analogous matters? This is a contempt matter which have been shown to us.
Very well, my lord
will kindly appreciate.
Record the submission.
No,
My lord, let me have the right to audience. My lord, maybe, my lord, my lord will kindly appreciate this matter has a checkered career. Though I have nothing, I am supporting their cause because they have come up before my lord that this property belongs to the custodian.
Yes.
We are akin to whatever he's saying. But my lord, since this matter is pending for days together, and if my lord sees my lord's orders passed previously, it has been adjourned on umpteen number of occasions.
Yes.
So be that as it, and the order which is being shown to us, lordship, is a contempt application. Contempt application. And my lord has the determination as of now. And contempt application always goes before the honorable judge who has passed the initial order. So if it is contempt, then it is bound to be heard by my Lord Justice Banerjee. But if it is not contempt, whether other matters are to be placed before him or are before him, my Lord, we are still in the dark because the orders which are being shown to us, going by this.
This is the petitioner's case.
Now, my lord, may I please? My lord, I just I just also want this matter to be taken up by this honorable court. As has fallen from my lord as senior, is also my lord right. Because I am not here.
Matters are under contempt. What about the other two matters?
My lord, other two matters are also before his honorable that honorable court.
So the
in one.
petition is pending.
Yes,
Not the
all those 4 matters are pending before the honorable Justice Banerjee. Now, my lord, what is the, yes. My lord, what is the problem? May
Contempts and 2 petitions.
Yes, 4. One of them, I tell you, let me just complete and thereafter, my lord, as seniors.
The petitioner's case. When the petitioner submits, I'll record his submission and release the matters.
May I just submit and thereafter, my lord, my lord, as senior friend will be replying. May I just submit?
Can't be helped.
But may I just submit? But I'm not also saying that this bench, this honorable bench should release. I may just make my submission before your lord. If I can take your lordship here, my lord, the order which is passed in this writ petition, which is before my lord. Lordship will kindly seize that
petition
order.
is before my lord, contempt is before my lord Justice Banerjee.
No.
All right, I stand corrected.
Yes,
I stand corrected.
And then what I have gathered.
My lord, let him submit, my lord, then if we have anything.
Yes, my lord.
Because we all want the matter to be heard out, my lord, nothing else. Every day we are coming, my lord.
I understand that. Even I am not shying away from hearing it.
My lord, I render unqualified apology, my lord. I have never said that. I render unqualified, my lord.
One bench and 5 before another bench, and the bench is already in session.
I bow down, my lord.
I cannot.
My lord, I am not making any submission with that in that regard, my lord.
I'll just record your submission and release the matters.
Lord, as your lordship, please, because I was trying to take your lordship to the matter which is pending before my lord.
Yes.
And if your lordship sees the order dated 9th of February, the first matter which is before my lord.
9th February?
Yes.
23? 21.
First, this is one of the second or third order in this particular matter. 9th of February, 2021.
This is also passed by Justice Banerjee.
Yes. Well, there your lordship see the number of the bunch of writ petitions.
Then how does this court, these records come to this court?
Now, my lord, what happens here, while I filed the contempt application with respect to 2 only. Among these 9 matters, I filed only 2 matters because lordship has passed this order with respect to those 2 matters. So after I filed the contempt application before the honorable court, my lord, while his lordship was taking the contempt petitions, contempt applications, my lord, it was proved that the state respondent, the alleged contemptor over there, have been, my lord, allegedly, it is my allegation that they were, my lord, flouting the honorable court's order. My lord, pursuant to that, my lord, his lordship has been pleased to pass order in the writ petition, that subsequent order of status quo as well. So this is the problem that we are facing here.
So it's better that you.
But as your lordship pleases, because his lordship, I being the petitioner, lordship only wants, what my learned senior friend is saying, my lord, is right. My lord, being also, my lord, the petitioner, here I came before the honorable court with the cause that I have been given a license. Let us say, my lord, the license was up to 2023 or 2022. So while I was given a license to possess over there, my lord, the private respondents are coming and recording their names and, my lord, encroaching the properties of my learned senior friend's client. I came here with the allegation that my learned senior friend's client is not taking care of his own property.
How did these petitions suddenly come before this court?
But now this is
Determination.
yes, because all those matters, my lord, though were tagged together, those 4 matters remained over there, and the other 4 matters somehow, my lord, were bifurcated.
The single bench still have the determination to deal with these matters.
My lord, since the contempt is pending,
That's in respect of 2 matters.
for 2
which are
matters, and
disposed of.
yes, all those 5 matters are now 4 matters are now together before my lord Justice Banerjee, in which 2 matters are, my lord, being taken up in contempt as well.
And 2, the writ petitions are pending.
Are pending, which is in court number 7, court number 6 of my lord Justice Banerjee, because those files are tagged together. I am facing the problem here. It is not anybody else.
So let
Now
all the
in this
files
meantime,
appear go before him. Let Mr. Justice Banerjee take a decision.
as your lordship, if my lord has releases this, then I will be, my lord, very happy, my lord, to come to your lordship, because
If he feels that he needs to release all the other writ petitions, he'll do that. And if he feels he'll take up all the matters together, he can, because a decision has already been taken by that court.
my lord, yes, my lord, this is what
And
is
if
the
all
problem
the
I am
matters
facing.
similar, if 2 have been disposed of, the other matters should follow suit, isn't it?
That is exactly, my lord, what I am submitting to your lordships.
So
Yeah, but
it will be difficult for this court.
So
2
I am also facing problem with the respect. Now,
Mr. Justice Banerjee, my lord, passed an order. Petition, my lord. Against that, my lord, he filed the contempt.
And 2 other
My
writ
lord,
petitions are pending.
No. That is not pending, my lord. How it is pending before he has the justice.
sir, tag
Banerjee,
doesn't
my
know
lord,
which chapter
has
এই 5টা
submitted-
আলাদা হয়ে গেছে। ওই 4টে আলাদা এই 5টা আলাদা ট্যাগ হয়ে গেছে।
Tag হবে কেন? My lord,
জানি না কেন।
that can't be in tag position. As because I appeared on the.
You appeared on the contempt
In
applications.
every cases, my lord, I appear.
Yes.
My lord, my contention is that, my lord, your lord content, my lord, in contempt. My lord, in contempt, I appear on every day. My lord, I am seeing that contempt matter is another matter, but other matter is not in the tag of the contempt matter.
Yes,
So
it is tag.
why others matter will not?
The order dated 9th February 2021 in this writ petition tags 9 writ petitions together. The order is passed that way. Out of these, if 2 have been disposed of, so the others follow suit.
Have
There will
they
be
been
separate
disposed of?
other petitions.
Or order is passed but not disposed of yet.
They have not been disposed of. It's an interim order passed, my lord.
My lord, for which my lord I filed the contempt over there.
My lord, interim
That's
against-
against an interim order.
against
Yes, interim order, my lord, that it should not be the private respondent, my lord, should not encroach on this. This is the interim order which is passed at first, 9th of February, lordship has seen.
Yes.
Now thereafter, my lord, what happens? There has been still encroachment going, and also, my lord, deeds were being registered. So I came before the honorable court by way of filing contempt. Now, my lord, his lordship has been pleased when while his lordship was taking up this contempt matter, modify the order passed in the writ petition also, and said that no further, my lord, change of title also should be done in the meantime. So those matters are also pending, my lord. Those orders, my lord, covers these orders as well. Now, what is happening there, my lord? Those writ petitions are along with the contempt are, my lord, before my lord Justice Banerjee. Orders are being passed, my lord, and this order, I naturally, my lord, had to take adjournment before the honorable court by saying that, my lord, lordship kindly passes the order. Whenever the matter will be finalized, I'll be placing this matter before that particular bench. Now, his lordship is sitting singly. When his lordship is sitting singly, then those matters are being taken up. So I am facing the problem.
What do you suggest? Because all the matters should be before one.
My lord,
So I'll be, my lord, mentioning the matter before my lord Justice Banerjee, and thereafter, if his lordship, if his lordship, my lord, releases this, then I'll once again come to your lordship and.
my lord, may
But he could do it,
I assist, my lord? May I assist, my lord? My lord has rightly said, 9 matters are to be heard analogously. Now, my lord, in those 9 matters, interim orders were passed that nobody should encroach.
by the bench having determination at that point of time.
Single order was passed.
Well,
Yes.
I stand corrected, but
Justice Banerjee was probably
my-
determination.
my lord, I'm on that. I'm on determination. As on that day, the Honorable Justice had determination. Subsequently, the determination has come to your lordships. Now, contempt application has been filed. What happens is, my lord, as soon as the contempt application is filed, the writ petition gets tagged with the
Yes,
contempt
yes.
application because it is to be heard in a holistic manner. So, under those circumstances, those two petitions in which contempt have been preferred has gone before my lord Justice Banerjee. It is not that the matter has been disposed of or it has been assigned to him. Now, my lord, the other 5, just because they have filed contempt in 2 only.
Matters.
My lord, they have been tagged. They have not gone for under his determination.
That is 2 matters tagged with the contempt.
Yes, my lord.
There
So
are
there,
2 other matters.
Those are also tagged. This is
There are 9
while Anna Senior friend is right.
There are 9
Those are tagged.
matters.
Order is passed in 2 contempts.
5 are here, 4 are there. Contempt in 2 only.
Yes.
The remaining 2?
my lord,
Must come before.
must come before my lord because that's an administrative issue that those have also gone. Instead of only 2 going, 2 matters going before my lord Justice Banerjee, the other 2 have also gone by mistake. Now, due to that mistake, my lord, if my lord releases these matters, then we will be running from pillar to post. Because if he goes before, in my understanding of the situation, before Justice.
What I say is that all these 9 matters, as they are running analogously, they need to be taken up by the same bench. Otherwise, there will be conflict of decisions.
But
So
that
if the
honorable bench
petitioner
has no
chooses-
determination.
If the petitioner chooses to mention before that the other bench and bring the matters here, let the matter be in the monthly list in that case. I'll not encumber
Whatever false. Then
Then
my lord will kindly pass.
necessary steps in the meantime.
My lord will
But
kindly
with
pass an
respect
order
to-
to that regard that he should take necessary steps. Because my lord, what is
Yes,
happening
yes.
is this matter
But-
is lingering from such a long
Right.
time.
Now, my lord, I am asking this question to myself, my lord. The problem I am here facing, my lord, when my lord is sitting singly, those contempts are being taken up there before my lord Justice Banerjee. Now, my lord, whatever order will be passed, because the order is passed in that, my lord, the problem I am facing, my lord, because these are analogous matters, same. Let us, my lord, say these are 2 there are 9 licenses. 2 licenses are there before the Honorable Justice Banerjee and the rest before the Honorable Court. Now, my lord, in the meantime, what is happening, my lord? Orders are being passed on the respondents that they should take care of so that no encroachment is being done. So accordingly, my lord, my lord, they were flouting the court's order, contempt, then they, my lord, complied with the court's order, then they complied. No,
We never collect.
The private respondents.
no.
Respondent, another matter.
Contempt is against the private respondents.
We are always, my
So,
lord.
my lord, after the contempt,
Contempt is against the private
no,
respondents.
contempt,
Respondent, I am
my
not-
lord, contempt is, my lord, against the state respondents.
Against the
Only
state
with respect to the fact
have
that they are not taking care of the private respondents' encroachment, the district magistrate and
That's
all.
not my headache. Contempt is not.
Yes, my lord, I may not
Yes.
want to come, contempt application come before your lordship, but why the repetition will be there, my lord? That is
So
my
let
question.
this appear in the monthly list. Please
Yes,
take
madam.
necessary steps.
I am grateful, my lord.
উজ্জ্বল, একটা কিছু করো।
রোজ কি আসতে হচ্ছে
That
আর 6 মাস ধরে
4 other writ petitions
Contempt করা হচ্ছে না। Contempt শেষ করেছে।
which were
অ্যাসাইনমেন্ট
taken up for analogous hearing along with the
তো
present
মামলা তো আর অ্যাসাইন
five
সবকটা ম্যাটার অ্যাসাইন করো
are before
মান্থ লিস্টে যখন অ্যারেস্ট করবে একই তো আমাদের সাবমিশন আমি এটাই আমি ঘুরেই
না।
চলেছি
Action করো যে ওই দুটোকে release করে দাও।
কন্টেম্প রিলিজ হচ্ছে
are not before this bench. Are not before this bench.
lying there with the content.
করাই হবে, এখানে যে order হবে তাই ওটা ইয়ে করবে।
Learned counsel for the
এগুলো add হবে না।
petitioners
নটা একসাথে হোক
submits
এখানে hearing টা
that
আপত্তি হবে।
স্যার আমি তো জাস্টিস
Content
ব্যানার্জিকে
করেছো,
রিকোয়েস্ট করতে
contempt
রিলিজ করে দিন
application
Hearing
have
accepted
been applications have been filed in connection with 2 of the 4 writ petitions which are pending before the appropriate bench. Learned counsel seeks to take necessary steps for consideration of all the analogous matters by the appropriate bench. Paragraph in view of the above, comma, let these matters appear under the same heading in the monthly list of April.
I'm great.
Please mention once you are ready. I'll take up the matters.
Yes, ma'am. Sir, last order দেখুন। Sir, last order দেখুন। Last order দেখুন কে ছিল না?
Next.
Blood under compelling circumstances, blood 20, 21, 22. Blood I was on the way, blood has been dismissed for 20, 21 and 20.
26 to 29. 20, 21, 22 কি করেছি? Not to report.
My lord's leave. Great.
On the earlier occasion also
Blood,
there was
one
no
day, blood
step.
that was dismissed for default, blood that was restored, and blood the matter was
How many times can a matter be restored, sir?
on many occasions that was blood adjourned due to blood non-availability of the blood.
Immaterial. You are the petitioner,
Blood
it is
that-
your
I
responsibility.
tender apology for this.
Not to report.
I will inform blood. I will inform and ensure their presence.
Yes, yes.
Great.
Same on 25 to 8 nahi na? 25 to 29 same. Monthly list of 8. ওই with ছিল আর 25 to 29 same order. Yes, next 30. 30.
হ্যাঁ হয়ে গেল হ্যাঁ ওই যে এসি ক্যাবেন ব্যস্ত
I'm for the petitioner, my lord. Lordship, previous occasion, your lordship direct us to submit the supplementary,
Yes,
but due to some reason of our client, we could not contact our client. That's why I'm paying for some time to file the supplementary affidavit. We could not contact, my lord.
Learned counsel for the petitioner seeks extension of time to submit the supplementary affidavit as sought. Paragraph, let the matter appear under the same heading on 22nd March.
Grateful, lordship.
My lord, I am for the petitioner led by Mr. Patputim Roy. My lord, state has served with a report in the form of affidavit, my lord. My lord, liberty may kindly be given to deal with the
Exception.
Well, I'm filing my.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Oh, this is that assessment in terms of the arbitral award.
Yes, my lord. Yes.
Paragraph, on prayer of the petitioner, liberty is granted to use an exception to the report. Paragraph, let the matter appear under the same heading on 14th March.
14. Grateful. My lord, I am for the petitioner, my lord. My lord, in this matter, both the National Highways Authority and the state filed their report, my lord.
Yes.
My lord, but we need some more time to file our exception, my lord. The fact, my lord,
You were granted
19
exception on the earlier dates also.
yes, my lord, on earlier,
Extension.
yes, my lord. If my lord allows me to file, extend the time, my lord, I will be grateful.
Counsel for the petitioners seeks extension of time to use exception to the reports submitted on behalf of the respondents. Paragraph, let the matter appear under the same heading on the earlier date was 14th.
It was, yes, my lord, 14.
14.
Lordship, in this matter, I'm appearing on behalf of the National Highway Authority of India. I'm led by Mr. Monica Roy.
Grateful.
Grateful.
Actually, my lord, I am for the petitioner.
But I appear for the added respondent, KMD.
Yes.
Lord, can one is for substitution. Petitioner have died on 3rd December 2022, and I have filed this application within time, my lord.
Can one to down here?
আমি তাহলে দিয়ে দিচ্ছি
The sole petitioner has expired.
Full petitioner has
I have not been served as yet.
I am serving here and now, my lord.
When did you file the application? Can আছে একটা?
1st February, my lord. 1st February 2023.
Can two-টা দিয়েছো? Can one দাও?
আমি can one copy আছে? এটাও তো
State respondents, Mr. Shishana Bandyopadhyay.
Yes.
Have you served a copy?
I am serving here and now, my lord.
For state? State you have not served.
State. I have served, my lord, but
I don't.
Please show me your
I don't
service.
see. Since you have not served me,
maybe, my lord, I am serving, my lord. I am praying for time to serve, my lord. তাহলে service. Can 2 already have been served, my lord.
Can 2? What is can 1 about?
Can
one is the substitution.
And
And
can
2?
Before substitution is allowed, can 2 has been filed.
On an emergent situation, my lord, I have compelled to file, my lord, can 2.
And you have not served the substitution application upon the respondents.
করিসনি করে
Can one.
what can my lord I ought to have been, my lord, it's my urgency. I do not know, my lord, why, my lord, this has been done. My lord, kindly, my lord, allow the substitution, my lord, and
Can't. It has not been served at all.
substitution service করে
Not served.
two-টা service করেছে,
1 of
one
23 was.
2টা serve করেছে।
দিদিকে বলুন।
state forest দেয়।
1 of 23 ও একটা আছে আরেকটা।
kindly fix it. Kindly keeps it any day, my lord. What happened, my lord? The illegal encroachment was there. For removal of encroachment, my lord, I came before this honorable court. Your lordship's court, my lord, directed an inspection to be done. In the meantime, the illegal encroachers have gone, and now, my lord, the state is allowing a mandir to be constructed over there.
And the state is also not doing it. Serve.
I shall come back. my lord.
Inspection.
Any day, my lord.
I'll give you.
After we were added as a party, my lord, of our own, my lord, along with the land acquisition authorities, we have done a local inspection. And we have found no obstruction in between the premises of the petitioner and the Kona Expressway. This is the survey report I have.
But I shall show before your lordship from Can 2 that now a mandir is now being constructed over there. They are not taking any steps.
That we are not concerned.
If the,
But
We are not.
the temple is with the.
No, this is not the property.
No, it's a state, my lord, it's a state property. Your lordship knows. For the purpose of my lord, carrying out any project, my lord, the state has acquired. There may be a vacant land, my lord, vacant strip of land that has not been utilized. But it is the duty of the state, my lord, to protect that. Under the, my lord, eviction of unauthorized occupants' land.
But don't you think the state can give permission for a mandir?
Yes, my lord, let the state come and say that they have given permission for construction of a temple over there.
So far,
It's
we
not
are
that.
concerned.
How are you
But
affected?
it's my ingress and egress will totally block. It's in front of my, my lord, building.
Please serve and come back.
Yes, my lord, I shall.
But this report, joint inspection report, does not say so.
No, my lord, this was the previous.
That was done on 14 March.
Our applicant
আগের বছর এটা আমি
is directed to
Oh,
serve
okay.
copy of the applications being Can 1 of 2023 and Can 2 of 2024 upon the respondents and file affidavit of service on the agenda date. Paragraph, let the matter appear under the same heading on 29th February.
my lord.
29.
Grateful.
Please serve both the
Yes, yes,
applications in the
yes.
meantime. অন্যটাও দেখে নেন।
আমি অ্যাপ্লিকেশন নট ইন ফাইল লিখবো?
Next.
Yes, not in file.
34, my lord, I beg to appear on behalf of the petitioner.
What happened in the year 1967-68, under Act 2, the land was acquired. But a construction of bridge has been made by the PWD department. But below till date below, no below.
A similar issue is pending before the Honorable Division Bench.
That was the submission of my earlier learned state advocate, Mr. Dotto. But I did not get any trace of that matter. And my learned friend on the other occasion also, my lordship was pleased to direct my serve the copy to my learned senior friend. Actually, lordship kindly consider.
So you say that there is nothing pending before the Division Bench. I'll record that.
No, yes.
Because there is a
Yes. Page 19.
But your lordship will come page 19, my lord. Yes, my lord, the estimate was there, but National Highway Division, National Highway Division.
State government के तो नहीं थी.
No, National Highway Division.
State government के नहीं.
Page 19,
Page 19.
Page 19, my lord.
Yes.
Paragraph 2, my lord. The estimate of Jawad was done with Ato at the executive National Highway Division at PWD roads. Bakura was requested to placement the fund for the purpose of this. My lord, now that is the last matter, my lord. So I may not want to, that estimate will not be the amount of this estimation. But National Executive and National Highway Division PWD roads Bakura must be a party of this process. But that was not, my lord. I would hope, my lord, my learned friend will add this. And my lord, your lordship can pass the order to the effect that the
Respond was 7, my lord. Probably, my lord.
This is a judgment. You're reading part of the judgment.
No.
Page 17, you said?
19.
19, my lord.
Yes, page 19 is part of a judgment.
No, probably this is.
Oh, this is the report. Give me a minute.
Actually, executive engineer is also a party.
No, my lord. National, there is a term, my lord, executive engineer, National Highway Division. That is also, my lord, one of the respondents, should be a respondent. Executive engineer, National Highway Division, বলে একটা আছে বাঁকুড়াতে।
I will correct it.
আরেকটা নিউ করে দাও না। একটা লিখনি একটা 8 নম্বর রেসপন্ডেন্ট আছে।
So it is admittedly lapsed.
Left.
So, my lord, I may not want to take that estimation. My lord, new estimation will be done by the authority, that is National Executive Engineer, National Highway Division, and placed before the DM, my lord, according to the permission of the direct purchase.
In terms of the 2013 Act.
No, my lord, that is the direct purchase.
Either direct purchase or 2013.
direct purchase.
Yes.
My lord, direct purchase.
So you are suggesting direct purchase.
My lord, that is more effective to us, my lord.
So shall I record your proposal for direct purchase?
Yes, my lord. Otherwise, my lord, it is not possible for.
Yes.
And
because your prayer is for compensation. You are agreeable to direct purchase?
Yes, I am agreeable.
For that, my lord, I am happy to do that.
But my lordship kindly consider, since 1966 till date.
Present market value. Current market rate.
ওইটাই হবে।
Third learned counsels for the parties. Paragraph, it is not in dispute that the land
compensation with regard to the years on which the case has been
এটা কখনো হয় না। ডাইরেক্ট পারচেজ করলেই তো তোমার হয়ে গেল।
টাকা পাবে
ওটাটাই
ভালো পাবে।
হ্যাঁ,
Fair Compensation Act অনুযায়ী 9.5% per annum
the land belonging to the
কেন বলছি ওতে টাকা কমে যাচ্ছে,
was sought to be acquired
এটা অনেক বেশি প্রেজেন্টেটিভ পাবে তো।
by the respondent authorities
ডাইরেক্ট পারচেজ হলে প্রেজেন্ট রেট অনুযায়ী দাও।
under Act Roman 2 of 1948 and The requiring body, comma, that is the executive engineer, comma, National Highway Division, comma, PW within bracket roads, bracket closed, comma, Bankura, was requested for placement of fund upon estimation of award to the tune of rupees 22929, 22,929. Stop.
My lord, my landed friend also, my lord, in case 22, rate for at the present market value. So there is no ambiguity of this, my lord. But page 22, last paragraph.
Yes, as for present market value, let the payment.
Yes,
be made.
yes. Since fund was not placed within the stipulated period of time, comma, the acquisition lapsed. Stop. The land has been utilized.
Yes. A bridge has been made upon which Milord,
The
that
land
became
has
the
been
main road
utilized
of Vishnu.
by the department. Stop. The petitioner prays for compensation in lieu of the same at the present market rate of the land. Paragraph. Learned counsel for the respondents, comma, in his usual fairness, comma, submits that the state shall purchase the land directly from the petitioner, since it has been utilized without acquisition. Stop. The petitioner is agreeable to such proposal. Paragraph in view of the above, the writ petition is disposed of, directing the
Respondent, my lord, respondent number 8.
8.
Yes, my lord, respondent.
No, Milord,
Landed
what my
respondent.
landed friend is on, Milord, my landed friend is submitting that the exhibit between National Highway Division, Milord, would be added as party respondent.
Yes, my lord.
Milord, I will incorporate
My
him.
lord, because he is the authority, my lord. He
Who will
take-
pay? Who will
Yes.
give the amount? Yes.
But the money will be decided by the land department.
Directing the 8th respondent for add korchi. 8th respondent to initiate proceedings.
Yes, ma'am.
Initiate proceeding for direct purchase of the land in question
And estimate the amount and send it to the.
at the present market rate. And conclude the proceeding upon payment of compensation to the petitioner as estimated in terms of the present market rate of the land within 4 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the district magistrate is the
Yes.
authority.
Milord, additional district. Respondent of 5. Additional LA. Land acquisition. তাহলে স্পেশাল ল্যান্ড অ্যাকুইজিশন অফিসার কোড করুন কোড দেখুন
Let 3 and 6.
3 months.
6 also, Mr. De.
3 and 8 months. Deputy Secretary Government of Hospital Land Development.
3 and 6.
My lord, he is not. My lord, 3 and 8.
The third respondent is directed to render necessary assistance for compliance of the order within the stipulated time frame. There shall have been orders course, since no affidavit or একদম শুরুতে করুন, on prayer of the petitioner, comma, liberty is granted to implement the executive engineer, comma, National Highway Division, comma, PW within bracket roads,
বাঁকুড়া
comma, Bankura as respondent number 8 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly.
Milord, for my understanding, Milord, respondent number 8 will decide or respondent number 3 will decide.
Now,
8 will initiate proposal
Yes.
and 3 will render all assistance.
Milord, because they are the requiring authority.
Yes. Yes.
Requiring authority to pay the money.
they'll initiate proposal and pay the money because it is not acquired, it is utilized.
Fine.
And third respondent will do the needful.
Fine.
The member of the purchase committee. That's the deal.
Liberty has.
Yes. Please do the necessary corrections.
35. Item number 35, Mr. Pankaj Halder is appearing for the petitioner. But if I am only paying for not to on his behalf.
Last
If I-
occasion also, several occasions of adjournment. Why don't you make your submission?
Because I'm not briefed in the matter, my lord, I do not have the brief also.
It's a group 9 matter.
My lord, I don't know, my lord.
Also, you do not know and you are
Mr.
making your
Haldar's-
submission.
Mr. Haldar's clerk, my lord, instructed me to, my lord,
On prayer of the petitioner, the matter is adjourned. Paragraph of the matter appear under the same heading on 27th March.
that's it.
You know.
I appear for the petitioner, my lord. Kindly sees my lord last direction dated 18 January, whereby my lord was pleased to direct them whether the notice of arbitration was served upon the petitioner or not. But the
Yes, Mr. Pondapadhyay, any?
My lord, I have not received any information. I'm saying.
My lord,
Yes.
my lord, before that, if your lordship kindly allow me to lordship to go through the writ petition, my lord. But if your lordship kindly allow me to read the prayer portion of the order, if your lordship kindly come the prayer portion, my lord.
Yes. National Highways has submitted a report, I find.
My lord,
You have submitted
my
a
lord,
report.
already filed my report, my lord. My lord, his prayer is lordship for the enhancement of the benefit of the compensation. And his entire prayer, my lord, his entire petition has been drafted on the ground of he is entitled to the benefit of section 24, my lord. My lord knows, as per section 24 is not at all applicable in National Highways Act as per benefit of 2013, section 24 of 2013 Act, my lord. His entire petition has been mentioned, he is entitled for the benefit of 23, section 24 of the 2023 Act, my lord. Which he cannot, my lord. He already citation one judgment in this writ petition. In the judgment also, my lord, it has been clearly mentioned this benefit is only applicable for the Land Acquisition Act 1894. And how, my lord, this writ petition at this moment, my lord, is maintainable, my lord. He has already received the enhanced amount of compensation. Now, my lord, he is asking for he is all not entitled for received any notice of the arbitration. Nowhere, lordship, not a single amendment is mentioned in this writ petition that he is praying for a copy of the award, lordship. His
He
entire
has
petition.
actually asked for only enhancement. He's not asking about.
My lord, he is asking for the benefit of 24.
paragraph 4, my lord, I have stated, my lord, the copy.
Petition,
My lord,
lord.
paragraph
Of the petition,
paragraph 4, my lord, I have stated, my lord.
24.2 stated. I do not find 24.2.
Paragraph 4, my lord.
In the prayers.
Well, he is asking for the benefit of 20.
Where is it? That is only one of the prayers, prayer G only.
My lord.
But the remaining prayers?
My lord, the remaining prayer, lord, he's already received the enhanced amount of compensation.
That's why it was asked whether he was served notice of the arbitration.
My lord, where it is his prayer, my lord? Where he is pleading for this?
Have you
He is
challenged this earlier order of the court?
My
There is
lord,
already an order of the court asking the respondents as to whether notice was served. Since you have not challenged that order, you have to comply with it.
my lord, my humble submission before your lordship, my lord, he is only in asking for the benefit of 24 Act.
Have you complied with the earlier order, madam?
My lord, that is lordship. The copy of the award is not my lordship.
Not copy of the award. Whether
No,
the
Dr. Bolton, notice
Yes,
your-
my lord, the notice is lordship.
My lord, I've
this was not served, he is entitled to an enhancement.
My lord, he has all as per section 24. My lord, how this section 24 is applicable in his case?
Forget about section 24,
But
not
his,
applicable.
lord, his petition is all about section
Other
24.
prayers also. There are other prayers
Well,
also.
kindly see the entire petitions of this lordship, the paragraph section, paragraph 4 of this writ petition. And his citation was cited one judgment, lordship.
My lord, paragraph 4, my lord, I have stated, my lord, the concerned competent.
He doesn't talk about 24.2.
My
My lord, let's lay down in section. My lord, you kindly come to page 6 of para 8, my lord.
lord, immediately, my lord, I have
made an
The
application, my lord.
petitioner herein had been seeking benefit under the principle as laid down in section 24 of the Right to Fair Compensation and Transparency Land Acquisition, Rehabilitation and Resettlement Act 2013. The authorities had ignored the same and had been trying
not
to
be applicable.
No, my lord, but paragraph 4, my lord, I have stated no my notice of hearing and as well as the
Kindly, my lord. After this, my lord, para 11, my lord.
thereafter, my lord, I approached, my lord.
Sir, my lord, kindly come to page 7, my lord, para 11, my lord. It would be relevant to submit that there had been description provided that the money payable to the land losers had been deposited with the competent authority, but the question which had not been answered is that whether that money had been deposited in the bank account of the land losers as per the provisions of law and as laid down by Supreme Court in the judgment, my lord. This judgment has been cited.
This is with regard to 1894 acquisition.
Now, how, my lord, this repetition is lordship is maintainable in this
That
regard?
is not the only prayer. Please do not attack the maintainability on this ground.
My lord,
He has other prayers also. There was a specific direction of this court to come up here.
My lord, my lordship, his first prayer, lordship, a writ of in the nature of mandamus to issue, commanding the respondents and each one of them, their men and agents, servants, associates, subordinates, administrators assigned to consider the application made by the petitioner along with the subsequent representations. My lord, and in terms of the published in 28th August, in the second prayer, my lord, a writ in the nature of mandamus to issue, commanding the respondents and each one of them, agent, servant, associate, subordinates, administrator assigned to consider the representations, my lord.
Yes, my representation, my lord.
On the representation, my lord. My lord, and the third lordship, a writ of in the nature of mandamus do issue directing the respondents and each one of them, their men and agent assigned to pay the compensation. To pay the compensation to the petitioner along with all benefits under the provision of the first schedule, second schedule, third schedule of the right to fair compensation. How, my lord,
these are some of the prayers.
Yes,
the
my
writ
lord.
petition entirely cannot be dismissed only on this ground. He is asking for enhanced compensation. Even if he is not entitled under section 24, he has other entitlements.
My lord, the other entitlements, my lord, he has already.
And your specific case is that he was granted the arbitral award.
But he has already enhanced amount, he has already received it. But nowhere not to mention in his petition that he has already received enhanced amount of compensation.
Paragraph 4, 5, my lord, I have stated, my lord. Paragraph 4, 5, my lord, I have stated that no notice was served, my lord.
Then next paragraph.
See, my lord, kindly see.
Paragraph,
Next paragraph.
paragraph C. Paragraph 6, my lord, I have solved.
Paragraph 5 ta পড়ো না।
Your petitioner state that the
Immediately I have approached the
arbitrator.
yes 2015, my lord. I have approached the arbitrator.
You arbitrator, you approach before the
My lord, his
arbitrator.
submission is other way, my lord.
You appeared
His
before the
other way,
he
my lord.
appeared
No, no,
before
no.
the arbitrator.
No, I did not appear. I did not
Compensation.
appear. I did not appear. আমি appear করলাম কোথায়? Misrepresenting before the
compensation.
my state is misleading the court, my lord. From the
তোমার লেখাটাই পড়ে দিচ্ছি ভাই, আমি মিসলিড করতে হবে কেন? তুমি যা লেখাটা আমি লেখাটাকে
Have you received the enhanced amount?
amount.
so, my lord, my lord, I have received
Sir,
that
no, sir.
in 2017 that amount.
You have
That
received the enhanced amount.
but
Have you stated that in your writ petition?
yes, my lord, I have stated.
Paragraph.
না না ঠিক আছে।
My lord, the paragraph 6, my lord.
So you have received two compensation amounts. in
No, my lord,
20
one. My lord,
2015 and 2017.
my lord, only one, my lord.
Payment notice P2.
But subsequently that was revised.
Lordship is categorically mentioned, Lordship, he received the enhanced amount of compensation, but he has not received the notice. He's in the last occasion, Lordship, he's categorically mentioned, yes, I have received the compensation. But
That
his writ petition is said otherwise, my lord. In the in section, in para 5, Lordship.
My lord, paragraph
What is the arbitral amount compensation?
my 2,52,918
That is the arbitral amount you have received that.
compensation received.
Have you stated that in your writ petition?
My lord, paragraph 6, my lord, I have stated that
It
payment.
says the payment notice was issued.
না না এটা তো
There is
পেমেন্ট
a
নোটিস।
line showing that you have received the amount.
আরবিটাল অ্যামাউন্ট লাগাইনি এখানে, আমার কাছেও নেই। আমার কাছেও নেই, আমি দেখা যাচ্ছে।
This is suppression of material fact.
My lord.
Yes.
Yes. But paragraph 6, my lord, I've stated, my lord.
Have you stated that you have received the
My
arbitral
lord, paragraph 9, my lord, I've stated.
paragraph 9? Yes, what have you stated? You say it has not been considered,
Payment.
whereas you have received the amount. Don't you think this is suppression of material facts?
My lord, in my letter, my lord, paragraph.
I'm asking about the writ petition. You have to disclose all the facts before the court if you are seeking relief.
Yes, my lord, but
Have you disclosed?
I have received the amount, my lord.
You haven't stated it in your writ petition.
But it should have been, my lord. It is not mentioned.
Withdraw to
Or,
disclose.
my lord, I am filing a supplementary affidavit, my lord. Disclosing, my lord. Only,
My lordship, he received the compensation without notice, my lord.
Is it a subsequent event?
my lord, only, my lord, since, my lord, admittedly, my lord, the no notice.
I have to dismiss on the ground of suppression of material facts. You should have stated this in your writ petition. You've received it sometime in 2017.
2017, my lord, that I have stated, my notice was issued, my lord.
Yes, but you have just kept quiet about the receipt of the amount.
But
Only to pray for enhancement.
prefer enhancement and as well as one.
Received on objection.
But that, yes, my lord, prior to that, I have raised an objection, my lord.
The arbitral amount.
Arbitral amount, my lord. Prior to that, my lord, I have in 2015, my lord, I have made an application, my lord.
Was there any arbitration? It was in 2017. I'm asking about the arbitration.
No, my lord. Thereafter, my lord, in 2020, my lord, I have again made a representation, my lord.
I have to dismiss your petition. I'm sorry.
No, my lord, my lord. The instructing advocate is not there, my lord. Kindly takes up tomorrow, my lord.
After all the submission that you've made, no,
My lord,
I
that
cannot
too-
wait for the instructing
No, my
advocate.
lord, to that effect, my lord. That
I can grant you liberty to withdraw. That's the only lenience that I can show. No, there is clear suppression of material facts. And your instructing advocate cannot come and add a line in the
No, my
report that, isn't it? You cannot improve on this. Yes.
yes, my lord. Then, my lord, the liberty may be granted, my lord. But admittedly, my lord, no notice has been served upon the.
How you receive the
But
How
they
did you
have not
receive
in their report, my lord, nor in their report of the state as well as the national.
You have received the payment notice, you have received the compensation.
But no notice of, my lord, the award was, my lord, the prior to that, no notice of arbitration was also, my lord, served upon the petitioner, my lord. That is our case, my lord. That's why my lord was pleased to direct them to produce that.
Withdraw, make a proper writ petition, file a proper writ petition with all the facts for the court. The basic minimum is you have to come with clean hand. This is a writ code. Our Honored Counsel for the petitioner seeks to withdraw the writ petition.
Is 34.
With liberty to file a fresh writ petition on the same cause. A writ petition or connect a line on the ground of certain defects detected therein. Withdraw the writ petition on the ground of certain defects detected therein and praise for liberty to file a fresh writ petition on the same cause of action. Paragraph in view of the above, the writ petition being WPS officer is dismissed for
My only submission, Lord, after receiving the compensation, or any adjudication is required, my lord, from your lordship part.
He can come, let him come. If he still feels, but if he is advised otherwise, he will not
My
file
lord,
a
they
writ
appropriate or reprobate at the same time, my lord. That is very.
He has been given a chance. Let us see.
My lord has.
If he chooses to come back again, we'll deal with it.
No.
There shall have no liberty to file a fresh.
But receiving amount does not take away my right, my lord. Subject to my lord's kind correction.
Yes.
My lord, receiving amount, my lord, with my lord, the with demand, my lord, that does not take away my right, my lord.
Yes, Lord, but the
arbitration proceeding. My lord, in the arbitration, my lord, the no notice was given, my lord.
Actually, like to see the notice served upon the
My lord.
notice of arbitration.
Without the note.
My lord.
Next. Come back.
My lord, this is my application.
Yes. Mr. De?
প্রথমটা কি নির্মল স্যার? Yes. My lord, the proceeding was initiated under the National Highways Act. Now, my lord,
I find the you are appearing for the
Oh,
union.
union officials. Huh? Oh.
The
No, my
report
lord,
has been submitted by the
yes, yes, by the
State
my
and
lord,
the
the state as well as the National Highway Authority. Now, my lord, admittedly, my lord, I was paid compensation. I don't have any grievance, so that, but the compensation, I have not come before this court on that ground also. My whole grievance is this, my lord, that if you also kindly turn to paragraph 9.
three petitions are being considered together.
Yes, yes. They are the in respect of the self-employed, the different owners. What happened, my lord, that I was directed to hand over the possession, and accordingly I was served with notice under section 3 capital E. Possession was handed over, and there was a measurement demarcation. They took over the possession. Now, subsequent to this, my lord, I understand there was an order by this honorable court in respect of self-employed, but in respect of the other portion of the land. Now, in the guise of that, my lord, the block land officer from the office of the borough, some people came to me and they started demarcating. Then I objected that you cannot do this because once demarcation is done, you have to cover the possession. Well, that is my paragraph 9. Then, my lord, I was told that no, I am not entitled to have served any notice for a hearing, and this is not you are not concerned with the measurement. Then, my lord, I drew the attention of the authority, my lord, this is that page. You will also find at page 17.
Yes.
I did not find any reply. Yes, then, my lord.
My lord, may I leave, my lord, for a moment, my lord? For a moment, may I leave, my lord, for a moment? I'm grateful.
Then, my lord, the reply is this, my lord, that page 18. This is to inform the hearing on such and such it has got no relation with this matter which is already settled, and so he has not been served with any notice for that hearing. So, admittedly, I was not served with any notice, yes, and I also not know what is the fate and why they came to my premises. Then, my lord, I move this writ application with the pair that not to give any effect if any hearing is being taken on in my absence without hearing me. Now, my lord, your lordship was kind enough to direct them to file a report on this. My lord, both the state and the
Acquired portion has been taken over by the authority.
my lord, I don't have any grievance and measurement
Not
done.
measuring they are demarcating your
Yes,
relative,
now they
portion.
have, my lord, there is no denial of my statement in paragraph 9. No person came to your premises. In the report, I have gone through the report, my lord, there is no denial to that. Now they are saying, now kindly turn to the, my lord, the report
of the National Highways.
National Highway Authority. My lord, the state is also, my lord, he has not said anything else, but page 6, paragraph 11.
Yes.
Now he is dealing with this, my lord, that the paragraph 9 of mine. It is further submitted that in paragraph 9 of the writ petitioner, the petitioner submitted that on 21st of January 2021, the BLRO official along other visited the subject plot. My lord, he has quoted this thing. Next, in this regard, next paragraph. In this regard, it is submitted that the contention and allegation of the petitioner to the effect as stated above are malafide based upon incomplete knowledge and are contrary to the matter of record. It is submitted that there was no dispute with regard to the area acquisition subject plot of as regard the petitioner is concerned. If that be so, my lord, then my allegation that your people came to me, there is no denial. So this cannot be said, my lord, that this is my incomplete knowledge. One hand, the person from the BLRO office is coming and taking measurement.
They say that they are taking measurement in respect of a owner's portion.
So co-owners is my lord, adjacent to my owner. So there is no occasion to come to my premises.
No.
And there is no denial that they did not come to my premises. That is my specific statement. And he is dealing with my paragraph 9 of the writ petition. So, my lord, what I am on today is this, my lord. My writ petition can be disposed of, my lord, indicating their stand. That they are whatever.
All land is not being
Yes, they are not no
consideration by
further.
them at all.
Yes.
Mr. De,
Paragraph 8 is very clear.
8 of
Page 4 of the petition.
page 4 of the petition.
You want my landesman, what's fine. Paragraph 8, page 4.
Yes. There's no dispute.
So there is any dispute, my lord, what my landesman wanted to.
No. The Mr. Pan says that after this,
After this, my lord, anyone goes there.
they are coming to the petitioner's land.
No, my lord, that can't be. It is not possible, Lord. Nobody can go in the land of
The petitioner also says that can't be.
Yes, madam. I also get my lord.
Yes,
And
yes.
the paragraph is very clear.
No, and the report of the NHAI says that they are not going to the petitioner's
Yes,
land.
madam. That
So
is
let me record that and
Yes,
dispose
madam.
of
My
the
lord.
petition.
Yes, madam. The prayer is very clear, my lord. So. No.
চিত্রলেখার জন্য দেখি ওর পেছনে একে দিয়ে গেছে এখন আমি অর্ডার বার করে না বুঝবি
It is not in dispute that Tarak heard learned counsels for the parties. Paragraph. It is not in dispute that a portion of the land of the petitioner was acquired
instructions কিছু বলতে হবে না কিছু কিছুই তো বলে না কিছু জানি না আমাকে বসেছিলাম ওখানে
and compensation paid to the petitioner for the same. Stop. Upon service of notice under section 3 capital E of the National Highways Act 1956, comma, possession of the acquired portion was delivered by the petitioner in favor of the authority a possession of the acquired portion of the land measuring 1.35 decimals out of 2 decimals was কি বললেন তারপর Stop. The petitioner is still in possession of an area measuring 0.65 decimals. Stop. Measuring 0.65 decimals. Stop. The petitioner complains that the Block Land and Land Reforms Officer, Chagda, along with his team, came to the portion of the plot owned by the petitioner on 21st January 2021 and started conducting measurement work without service of notice to the petitioner. Stop. In reply to a letter sent by the petitioner to the competent authority and additional district magistrate, within bracket land acquisition, Nodia, on 29th January 2021, the petitioner was informed that the matter had no relation with the petitioner's land and therefore no notice of hearing was served upon the petitioner. Paragraph. Placing reliance on the report in the form of affidavit submitted by the third respondent, comma, no, placing reliance the report in the form of affidavit submitted by the third respondent demonstrates that there is no dispute with regard to the acquired land and measurement was done in respect of a portion of plot number 271 which belongs to a co-owner. Stop. Such measurement has nothing to do with the portion of the plot owned and occupied by the petitioner. Paragraph. In view of the above, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. Which language?
And my lord, so far the third writ petition is concerned, my lord, that is item number 41. That is, my lord, point.
This order will cover 37, 38, and 39.
39. My lord, 39 only area, my lord. I am in possession in respect of the area 1.19 decimal. Yes, paragraph 8.
So let there be separate orders.
Yes.
Yes. I'll just call one by one because they are also mentioned separately.
Yes.
Because the area will be different in the.
My lord.
The plot is the same.
Plot is the same.
Yes, let me call the Didi for next.
Yes, I am for the petitioner.
I am for the Union of India, my lord.
I am for the NHI lordship.
Here also there is a similar report.
Yes, similar report, my lord. Same report. There are two brothers. I do not find any
You are
change.
still occupying one decimal here, I find.
Yes.
Which is যেখানে ওখানে 0.65 ছিল না, the petitioner is still occupying. এখানে one decimal. বাকিটা same হবে.
All are same.
বাকিটা same হবে. Next. নাহলে গন্ডগোল হবে, আলাদা আলাদা।
And here, my lord. Possession taken over in respect of 0.
This is 1.19.
Yes, I am in possession.
আচ্ছা এখানে
And area acquired 0.0081 decimal.
Possession taken over যেটা বলছি acquired, 0.0081 decimals. 0.0081 decimals out of 2 decimals. It out of 2 decimals আছে ওখানে। Our petitioner is still in possession of 1.19 decimals. ঠিক আছে? Clear? বাদ চলে যাচ্ছে আপনার ডিকটেশনে। ওয়ার্ডস বাদ চলে যাচ্ছে, খেয়াল করুন। কারেকশন প্র্যাকটিস দেখুন। 40. Yes. 40 টা লাগে।
Lord, this is my exception.
Superior. You are the petitioner in both the matters?
I am for respondent number 7 and 8.
You're submitting an exception today?
Yes, ma'am.
Exception cannot be taken into account.
Yes, what is the matter about?
Yes. No, my lord, Jila Prasad. I am a, my lord, the owner in respect of an area, plot number, my lord. And that is the admitted position with the so far as my ownership is concerned. Now dispute arose when at the instance of the respondent, a construction for approach roads towards a bridge started. I came before this court, my lord, saying that without initiating any proceeding, you are encroaching my land, encroaching a portion of my land, construction is being going on. Now, they said no, that they are constructing the approach road on the existing road. Now there is a dispute pertinent to my lord from the Mauja map that CS and RS. In CS map there is no indication of a road. Now my lord, I am not on that. Now when I came before this court, my lord, this honorable, they took a plea that so far I am concerned, there is no allegation. So far this petitioner is concerned. So far this petition is concerned, my lord, your lawsuit taken up 4945 or 20.
But 40 and 40 were analogous.
Yes,
Similarly.
yes.
Now allegation is against the secondary petitioner that I am always obstructing the officials, etc., etc. That is against. So far I am concerned, my lord, there is no, so far this there is no allegation. Now, my lord, this honorable court, your lordship will find the Shomitor order ta ache re. Kunta? Answer for the order of justice, my lord, kindly see, my lord.
Division bench order.
No, my lord. My lord, Justice Vishwajit Basu was pleased to direct my lord to file a report. First, my lord, we have filed a report by the district magistrate. Learned advocate of the petitioner is not satisfied with the order, with the report. He prays before the honorable court. He prayed before the honorable court for joint inspection. My lord, your lordship, kindly take up my report. Last report, my lord, filed by the district magistrate. That is on 13th April 2021. I have annexed the order passed by my lord Justice Vishwajit Basu. Order dated 5th March 2021. My report dated 13th April 2021. सर पहले नहीं
10th November 2022 is 7 and 8's report.
Last order passed by my lord Justice Basu, my lord, on 3rd. But file.
Give me a minute.
It appears from the order sheet, my lord, also. It also appears from the order sheet also. 5th March 2021.
Not find your report.
No, I have filed, my lord.
This is all by
Sir, Lord, kindly go through the my lord order sheet passed by my lord Justice Basu.
Stated report, sir. Stated report.
No, Joseph, Joseph filed the order of the Justice Basu order.
You filed in the first matter, no?
I have filed my lord 2 reports. First by the district magistrate, second joint inspection report. It's a order. It's a by filed by the assistant engineer on 13th April 2021. The order passed by my lord Justice Basu is annexed with the report.
I did not find the report at all. Seven and stated report. The Jila Purishad report.
Report Joseph ka nahi. আমার কাছে তো এক্সট্রা কপি নেই, এটা তো দাম মেরে বসেছে। আচ্ছা আচ্ছা আচ্ছা, my lord, I'm sorry, my lord, it is along with me.
Not file. File it.
Sorry, my lord,
File.
এটা কোনটা রে অসমীত?
প্রথমটা
প্রথমটা মানে কোনটা? একটা কপি দে না আমাকে।
তোমাকে দিয়ে আছে তো, আমি দিয়ে দেবো তুমি, এখনই দিয়ে দেবো। আমার কাছে কপি নেই আর একটা,
না, না,
আমারটা দেখে করো।
ডেটটা বল, ডেটটা বল।
পেজ 10, my lord, লাস্ট প্যারা, annexure, my lord,
ওই 13
13/4.
এটা নেই, এটা আমি দিই।
Yes. The inspection was
According to
done.
inspection held, my lord, with prior notice, they were present, and what I said, all is annexed to it, my lord. And it is found, my lord, the PWD authority, my lord, you will also go through the order, report. PWD authority, my lord, constructed exclusively on the PWD land, that is RS plot number 554/305. And petitioner's land is 4047/3, that is not touched. Therefore, my allegation of the petitioner that his land is, my lord, earth is excavating, his land is damaged, it is not correct.
Let us hear the petition, Mr. Khan.
Now, my lord, let's kindly turn to the order of the division bench.
Order of
the division bench. Now, let's kindly, before that, my lord, once again, kindly turn to the annexure, of the report, the order of Justice Basu.
annexure to the report.
Paragraph 11, page 11.
Of the report.
Yes. Now the
Justice Basu's order.
Yes.
Yes,
Now
the
they
last
took
page.
advantage of this language, of this line of his lordship. The last but one paragraph. The said inspection shall be conducted upon prior notice to the petitioner, and the petitioner is free to participate in the said inspection, but would not cause any disturbance in the said inspection. I was prevented to raise any objection to that regarding the measurement. This was done unilaterally. Then I approached the division bench. Kindly have a look at the order of the division bench. Did you get a copy of it? They are heavily banking upon this measurement, which has been done unilaterally, ignoring my objection.
Division bench is ordered on 10th.
10th of November 2021.
Yes.
Lordship, kindly, I will not trouble your lordship to go to the entire order. At page 3. My lord recorded my submission, and accordingly, my lord, liberty was given to me. Paragraph page 3. As regard the grievance of the appellant regarding C not being permitted to effectively participate in the inspection, the appellant may raise such grievance before the land single judge. So today, my lord, today I am before your lordship against this, pursuant to the liberty given by the my lord, I filed a my lord, I filed my exception, and there is no reply to that. Yes, my lord, kindly see my exception.
Let there be a further inspection.
Yes. Let there be a joint inspection, my lord, everything will be solved. If
Again, my lord, he will raise this question. My lord, your lordship, can't.
Do you intend to appoint
Special
a
officer.
separate- a separate
Special
army
officer.
from your side?
Yes, yes.
Special independent Malon Amin.
The
Let there be
petitioner will
independent
engage-
Amin.
Officer by the honorable.
Petitioner engage his army, you
Yes.
will have the government army
Yes.
with you, let them do it jointly.
Yes,
My lord.
kindly do that.
Heard learned counsels for the তার আগে করুন exception used by the petitioner to the report submitted on behalf of the state respondents is taken on record. Heard learned counsels for the purpose.
লিস্টটা পড়ে এখন তো হচ্ছে না, এটা তো আমসার আছে। আমসারটা ফটো দিয়ে দিই।
By an order passed by this court
দিদি
on 5th March 2021
দুটো
in WPA 4945 of 2021. The fifth respondent was directed to cause an inspection of RS plot number 47/303 to ascertain whether the said DAG was exploited in any manner in execution of the work. Stop. Such inspection was conducted in presence of the petitioner and a report petitioner and the report submitted on behalf of the state demonstrates that upon joint inspection and verification, it was reported by the Block Land and Land Reforms Officer, Debra, that the PWD has executed construction work exclusively on PWD land in RS plot number 54/305 and no portion of the Rayati land of the RAIYATI. Rayati land of the petitioner has been exploited for such construction work. Stop. The petitioner was aggrieved by the said observation
এইটা কোথায় পেলোস?
on the ground that he was not allowed to
রাইটের সূত্র আছে,
participate
ভাবতে হবে।
in the joint inspection, though he was
ওরা কি
present
বলবে?
therein.
দেখ, রাজস্বী করছে না? আছে এই কেসটা, এটা ছাপিং করতে বলো তো। সাইটে এসে ছাপিং শিলিগুড়ি সিভিল জাজ সেকেন্ড কোর্ট মিদনাপুর।
The petitioner approached an honorable division bench of this court in this regard, and by an order passed on 10th November 2021 in FMA 717 of 2021, the honorable division bench disposed of the appeal with liberty to the petitioner to raise her grievance before the learned single judge
হ্যাঁ, লিখে নাও।
and file her exception to any report that might have been filed on behalf of the respondents before the learned single judge. Stop. Pursuant thereto, the petitioner has filed an exception to the report submitted on behalf of the state respondents. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since the petitioner is aggrieved by the fact that she was not allowed to participate in the joint inspection despite being present at the relevant time, let there be a fresh joint inspection of the plot in question in order to ascertain whether the plot owned by the petitioner, being RS plot number 47/303 or any portion thereof, has been utilized for the construction work made by the PWD. Stop. the petitioner shall be at liberty to appoint her own Amin for the purpose of such joint inspection in addition to the Amin appointed by the state respondents. The petitioner shall also be at liberty to participate in the joint inspection held by the respondents. Paragraph, report of the joint inspection be submitted before this court on the adjourned date. Paragraph, let the matter appear under the same heading on 1 month should be sufficient.
Yes, madam.
Mr. Bandyopadhyay?
I don't know. I shall try, my lord. I shall try.
But let there be a direction for fixing up a date for joint inspection, so that
এত তাড়াতাড়ি বলবো কি করে অফিসারদের সাথে কথা ডিপার্টমেন্ট
এক মাস যথেষ্ট।
আরে না অনেকগুলো দপ্তর আছে না, জেলা পরিষদ আছে, এরা আছে, কথা বলে নি ওটা নিজেরা, বিএলআরও আছে, হয়ে যাবে আশা করি, এক মাস হয়ে যাবে, এক মাস is sufficient.
Anyway, my lord, I will not
Joint
insist.
inspection be held যেখানে বলেছেন ওখানে upon notice to the petitioner. Fresh joint inspection be held বলেছেন by the upon notice to the petition. আজকে হচ্ছে second 20th March.
My lord, deeply obliged.
Let the matter appear under the same heading on 20th March.
But next matter, my lord, is the same. But I am filing my
Together actually.
yes. I am filing my exception to
এটা নিয়ে নিন দুটোই 40-41
Didi, এটা আমার exception. আরেকটা
Both the matters will be covered by a common order because it's together.
yes
Lord. Only the plot numbers are different. Here is plot number is 86.
In the second
The
matter.
second matter.
Rajiv,
ওটা কি
plot number 86 for the second one.
56. 56.
প্রথমটাতে বলেছি না plot number? Petitioner's plot is 56.
Petitioner plot is 56. This side and that side.
No, it's not Bata.
No, only 56.
Only 56.
Only 56.
The plot একসাথে অর্ডার হবে কিন্তু এই প্লটটা যেখানে ওই বাই 303 যেটা বলেছি ওটা ইন WPA নাম্বার আছে আর প্লট নাম্বার 56 ইন WPA নাম্বার সেকেন্ডটা নাম।
Deeply obliged.
রিপোর্টটা হলো
20
ঠিক আছে বলে রান ফর দ্য স্টেট রেসপন্স
Yes.
Two Lordship praying for not today Lordship in this one. On behalf of Mr. Partha Pratim Roy Lordship, I am praying for
Exception.
exception Lordship. We have not filed.
Not ready.
Not ready.
Learned counsel for the petitioners. Rajiv, learned counsel for the petitioners seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 14th March.
As well as
14 মার্চ লিখে দেবো ডিপলি
Aman.
But 43, I appear for the response number 4, West Bengal Housing.
Lordship, in this matter, Lordship, Mr. Devashish Shah is appearing for the Asansol Durgapur Development Authority, Lordship.
Yes.
Due to some personal difficulty, has not come to court, Lordship. I'm humbly praying for not today, only not today.
And not today, not.
Petitioner.
No, but petitioner.
Who is appearing for the petitioner?
Oh,
None appears for the petitioners. No accommodation is sought. Paragraph. Learned counsel for the second respondent also seeks accommodation. Paragraph. Let the matter appear under the same heading on 21st March.
Lordship, good.
No, ठीक है. But instead of 21st, any other day, 22nd or
Second.
22nd. March.
Rajiv, 22nd.
Your Lordship, I beg to appeal for the petitioner, Your Lordship. Your Lordship, in this matter, on the last occasion, Your Lordship, that is the 19th December, Your Lordship, a prayer was made by the WB SETCL. Liberty is granted to reaffirm the report in the form of affidavit, since according to the learned counsel, the original report is misplaced. And Your Lordship, the learned counsel for state respondents seeks extension of time to submit the report in the form of affidavit, Your Lordship. Till date, we have not received any report, Your Lordship.
Last occasion, we submitted before your lordship that. No, I don't think there will be any problem. May I? Now, Milord,
Are you
last
filing
occasion,
a report today?
yes, because we have been able to trace out that.
The first report, original report.
Yes. May I? No, and copy was already been.
Yes, let's hear what is the matter about. Have you received a copy?
Yes, Your Lordship.
sir.
Your Lordship, I may use an exception, Your Lordship.
Yes.
And Your Lordship may direct kindly to serve us the copy of the affidavit, Your Lordship.
Already served. No, we have already served.
You have not received a copy of the
No, Your Lordship, I have not.
Just now said yes.
Then I have to take instruction, Your Lordship, regarding that.
I hope my.
If Your Lordship, one copy is there,
Yes. It shall serve, again I shall serve. If he needs,
Please serve because you had also misplaced.
obviously
Please
we
serve.
serve him. But not served, this is not correct, Milord.
Mr. Dey, you get another chance. Please file your report on the next date. No, not first time. You sought extension on the earlier occasions also. Oh, you're always taking 2 or 3. So I'll grant you 2-3 extensions at a time so that you don't take the next extension again.
Your Lordship, subject to correction, Your Lordship, then I will use the exception in both the affidavits, Your Lordship.
Has to come.
Dep-
Very well. Report in the form of affidavit submitted on behalf of respondent numbers 5, 6, and 7 is taken on record. Paragraph, learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, on prayer of the petitioner, liberty is granted to use exceptions to both the reports. Paragraph, let the matter appear under the same heading on 20th March. Mr. Dey, sufficient time.
Deeply obliged.
Next.
Would it be possible for you, Lordship, my juniors are very personal I mean, any day after.
22nd?
22nd.
Or after that week?
That
So
week.
let it be 27th.
27.
Yes.
Lordship.
27th. Rajiv,
27 তো ওইটাই ছুটির ভেতর পড়ছে তো দোলের ছুটি আছে না মার্চ 27th.
There are holidays in
Yes,
between.
that's right.
Holy.
So let it appear the first week of April to be abandoned
The
custom.
petitioner will have an objection, sir.
Do you have objection?
Of course, has to be.
No, I am asking.
27.
I was not aware.
Yes, next matter.
My lord, I am for the petitioner, my lord. My lord, this matter is of year 2021, my lord. My lord, I think, my lord, those advocates, my lord, the panel has changed, my lord. My lord, if your lordships kindly directs me to serve.
45. আমাদের brief net.
My lord, I will serve and come back, my lord.
Mr. Bandyopadhyay is appearing.
Well, I am appearing, but no briefing.
My lord, I will serve, my lord, and come back.
I'm not I'm not
My lord.
making any order, but please give him.
I will serve, my lord.
Yes.
এটা আমার কপি দিয়েছিল
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter. Are there any private respondents also? No, only the state.
My lord, my lord, I think, my private respondents are there, my lord.
So, have you served the?
My lord, I have served, my lord. Affidavit of service is ready.
Private, have you served the private?
My lord,
respondents?
my lord.
Please find out.
অন্য কাটা কাগজ দে না যে চাইছি সেটা দিবি
There are 5 private respondents. Have you served all of them?
My lord, I have served, my
If not, please serve in the
My lord,
meantime.
my lord, my
Right?
lord, I will-
You're getting another date.
my lord.
Let the matter appear under the same heading on 20th March
My lord.
20.
Grateful, my lord.
লিখে রাখ
Mention.
Thank you.
But I am for the petition.
এই নম্বরটা দিবি
হ্যাঁ
ঠিক আছে আমাদের কাছে
My lord, item number 669, my lord. I am for the petition. 689. I am for the petitioner, my lord.
Yes.
My lord, this is a land acquisition matter, my lord.
Have you
My lord,
served?
it was served. My lord, it was served earlier. Thereafter, my lord, I have served again.
Roy is appearing.
I served again
Who is appearing?
because they have on the
Mr.
last.
Roy is appearing for the NHI authority. And what about the state? But you are appearing in this matter. The state is seeking an adjournment today.
My lord, then tomorrow, my lord.
Not today. Regional file has not been received. Some time is required, I think.
But then on Monday, my lord, because there's an urgency because the road, my lord, is being constructed and without giving me the compensation, my lord.
No urgency. You will be getting compensation if your the road is constructed also.
My lord, the problem is how the road is constructed. My land marker become low and there is free ingress and in.
Mr. Dey
I'll give
for a copy.
my lord, in the course of the day, I'll hand over. In the course of the day.
Not this week. Maybe not this week.
HON'BLE.
entry
I am first in, my lord.
Service complete?
My lord, there are several private respondents, my lord.
Have you served all of them?
All of them served, my lord. My lord, instruction.
That one?
I have received instruction. Can you see the instruction? This is help type,
12 not served.
My lord,
12.
12. Private respondent. Akshit Singh.
Anyway, what is the matter? No one is appearing for the private respondents.
My lord,
Appearing for the state.
State, my lord, I am first in my.
You're appearing?
He hand over instruction. Instruction. I have.
Yeah, what is the matter about?
My lord, the matter is, my lord, the petitioner's land is there, my lord. I have annexed the record of rights, that is page 28 and 29. My lord, in front of my land, my lord, there is the PWD road. But between the PWD road, there are some persons on the PWD road, my lord. And my lord, they are not, and in the said place, my lord, there is a office of bank, school, etc. However, my lord, so page 28 and 29, my land.
Concerned?
This is my land, PWD road. In between my land, the respondents are running their business. My lord, at present, my lord, what happened? a notice inviting tender was issued for widening and strengthening the road. My lord, they are there, my lord. Thereafter, the block development officer issued notice. Sorry, my lord. Thereafter, my lord, sub-divisional officer issued notice to the said private respondents. My lord, section 10(2). But they have not, my
So
lord.
proceeding has been initiated.
My lord, thereafter, they moved a writ petition before this Honorable High Court public interest litigation. The private respondents. The order is page 54.
Page 54.
54, paragraph 3, my lord. While take the decision, fifth respondent should bear in mind that roads and road margins are meant for free movement of the public and the traffic, and there cannot be any hindrance to such activities. Equally, so are the pavements, which are meant for the pedestrians. So, my lord, with this observation, the writ petition has been disposed of. But till date, the respondent authorities are sat right over the matter. Thereafter, the instruction has been sent before your lordship. Kindly go through the instruction.
And this is by one of the encroachers.
No, we are not encroachers.
Sheikh is one of the encroachers.
Yes, my lord.
He is a party to this writ petition?
No, on the public interest litigation. Most probably not. Nurab Sheikh, one of the businessmen of that area, who has received 10(2) notice. The notice I have annexed, my lord.
So proceeding has been initiated.
Yes, my lord. Sir.
Let that be completed.
All is completed, my lord. Only, my lord, assistant engineer PWD Kandi subdivisional wrote a letter to OC with a request for setting the police assistant, my lord. But till now, my lord,
it has been completed.
Yes, my lord.
10(3). Where is the 10(3) order?
Yes, my lord.
10(2) order to charge.
10(2) order, my lord. On Annex D, my lord, of instruction.
This is 10(3), right? Yes. Nothing further remains.
That's why, my lord, I am praying before your lordship, let the order be executed by the concerned authority. 10(2) proceeding has been completed.
It's over. Yes.
No. But my lord, police authorities sat tight over the matter. That's why the encroachment has not
give any direction to the police authority to consider.
No, that I am not praying before your lordships.
So nothing further remains in this writ application.
No, but they, my lordships, kindly see. If lordships kindly go through the instructions.
They have written to the police will implement the order. That's all. That part is only left.
My lordships kindly that much may be recorded and disposed of, and lordships directed them to hand over a copy so that I can go in a police in action.
Hand over a copy of what?
The instruction, so that I can go before
Please give a copy of the instruction to
my lord, instruction of police authority, my lord, says that any order passed by the Honorable High Court upon us. Kindly see instruction of the police authority.
Please hand over a copy of this to learned counsel. Copy of the instructions. Dekhi didi oটা কি দিচ্ছেন না?
Ultimately, the road is not strengthening, road is not widening. We are moving pillar to post, my lord. Because they are the influential persons, they will not vacate the said place. Even after the order of the Honorable High Court. In a public interest litigation, lordships kindly see the order. Road margins and pavement should be vacated.
It is correct. They say that the writ has nothing, no complaints against the police. There is no complaint against the police. This is not necessary. Let me pass an order. Affidavit of service. None appears for the private respondents despite service. Paragraph. Instructions submitted on behalf of the state respondents is taken on record. Paragraph. The petitioner complains of unauthorized construction raised by the private respondents by encroaching upon PWD road adjoining his plot, comma.
In front of us.
Yes, adjoining.
My lord.
Thereby obstructing his egress and ingress. The petitioner শুরুটা কি বলে করলাম complaints of the petitioner has sought removal of such encroachment
and even representation also.
and submitted a representation in this regard before the concerned authority on where is your representation?
My lordships can be page, it starts from page 30. Starts from page 30.
The petitioner made several representations before the authority in this regard. The petitioner made several representations before the authority in this regard and pray for a direction upon the authority to consider the representations at the earliest. Paragraph. Pursuant to such representations, placing reliance on the instructions submitted by him, learned counsel for the state respondents submits that pursuant to the representations submitted by the petitioners, petitioner, proceeding under section 10 of the West Bengal Highways Act 1964 has been initiated and concluded by an order passed under section 10 within bracket 3 of the Act. Stop. The assistant engineer, PWD, Kadi, by a letter issued on 10th October 2023, requested the officer in charge, Barwan Police Station, BURWAN, Barwan Police Station, Mushidabad, to Mushidabad for assistance for removal of the roadside encroachments.
My lord.
Paragraph. A public
My lord.
interest litigation was filed
by respondent number 41.
My lord, I am for
By
the private
respondent number
respondent.
41. Public interest filed by respondent number 41.
My lord.
41.
My lord.
My lord, I am for the private
You
respondent.
must be aware that when a court dictates an order, you're not supposed to intervene.
I apologize.
Page 10, 41.
A public interest litigation was filed by respondent number 41 and by an order passed on 21st August 2023 in WPA within bracket P 410 of 2023, the Honorable Division Bench has held that the roads and road margins are meant for free movement of the public and the traffic, and there cannot be any hindrance to such activities, equally so are the pavements which are meant for the pedestrians. Stop. The Honorable Division Bench left the matter for consideration by the subdivisional officer, Kadi. Paragraph. Upon consideration of the submission made on behalf of the parties as well as material on record, this court is inclined to hold that since proceeding under section 10 of the Act of 1964 has been concluded and the issue awaits removal of the unauthorized construction with the assistance of the police, it is expected that such assistance shall be rendered by the Have you implemented the police authorities?
My lord,
Ninth respondent.
my lord, only 1 second, my lord. My lord,
By the ninth respondent and the encroachment removed at the earliest. Paragraph, since nothing further remains to be adjudicated in the writ petition, comma, the same is disposed of. Paragraph
my lord, at the earliest, but positively, kindly give some, otherwise, my lord, need will be.
earliest, comma, not later than one month.
My lord,
1 month from the date of communication of this order.
grateful, my lord. Highly obliged.
Earliest, comma, the not later.
My lord, this matter was mentioned, my lord, but we have not received the notice, my lord.
An order has been passed. You've missed the bus. I can only record your name. You want to give your name? You're appearing for the private respondents?
Yes, my lord.
Bashu, Bashu, none appears se kete din, onar namta record korbe. Next.
But I am for the Kishama.
Have you served?
Lordship, served after mentioning for upgradation that has also been served, my lord, they have received the same.
Mr. Desatin,
My lord,
where is the service, the private respondent? Your affidavit?
well, the main copy was served in the evidence service in respect of that, and my lord. One private respondent is there, my lord.
Grateful.
Yes, he is served.
Lord.
Yes, what is the matter about?
My uniqueness prayer of petitioner, my lord. My lord, they made an application before the concerned BL and LRO for demarcation. My lord, the dispute is that, my lord, that he's over his land, encroaching some portion of that, my lord. The responding authority, my lord, raised some construction illegally. So I made application.
Authorities raised construction.
Lordship.
Respondent authority, the state raised construction.
But respondent authority raised some construction, my lord, and I made an application, and over that issue, my lord, page 30, the concerned BLR was directed.
Why have you implemented the private respondent?
Private respondent, because my lord, taking advantage of that construction, my lord, unauthorized construction raised by the concerned respondent authority, they are, my lord, disturbing my position. Page 30 is, my lord, the order passed by the landed executive magistrate.
Please come to paragraph 5 of your petition. Your allegation is against the private respondent.
Lordship.
Not
Because,
against the state.
Lordship. But my lord, kindly come to page 30.
This is a private dispute.
No. Page 32, kindly see, my lord.
Yes, page 30.
Page 32. Second, third paragraph. উক্ত সাচেন সাজ বর্গফুট জায়গা, my lord. The next skip can বহরমপুর পৌরসভা
This is a 144 CRPC order.
ভুলবশত রাস্তা করে. Yes, the বহরমপুর পৌরসভা, my lord, they raised
30.
page 32. Third paragraph. Second line. বহরমপুর পৌরসভা, my lord, ভুলবশত রাস্তা করে. Over my plot of land.
Where is the averment in your writ petition?
No, my averment is to that effect, my lord, that as the Bahrampur Purushabha, my lord, without following the process of law, has raised, made.
Stated that in your writ petition.
Or in my writ petition, I have totally, my lord, arranged that.
Your allegation is only against the private respondent.
Right, because he is disturbing.
So the writ petition is not maintainable at all. How is a private dispute maintainable before a writ?
I have made a representation to the BL and LRO for demarcation.
Directed to be considered by writ court.
No. BL and LRO, my lord.
The public element in your writ petition.
But my lord, kindly see, my lord, my representation to the BL and LRO for demarcation.
Show me the public element in your writ petition, sir. Any averment in your writ petition against the state?
BLRO was considering not my representation.
Okay, where is your allegation against the state?
But I'm
The infringement, whatever you say, where is that in your writ petition?
I have not made direct allegation against the state authority. Only to that effect, I have made that the BEL and LRO should, my lord, consider my case and demarcate the land in question, so that the problem will be solved.
For the dispute between you and a private party?
No, that is not. Because, my lord, yes, to that effect, my lord, I have not made.
It's not maintainable, sir. I'm sorry.
Well,
This
may I?
is purely a private dispute.
May I pray?
My lord, if your lordship come page 30.
Yes, I've seen page 30.
My pray one thing, my lord, before my lord.
তুমি অনেকক্ষণ বলেছো, এবার আমি বলি।
Huh?
Now my turn. My lord, your lordship will see. Had the advocate for the petitioner, Bharapur BLR is directed to demarcate the suit land as per government rule.
Yes, 145 order.
Yes, my lord, that there is no any rule. So now, my lord, page 28.
Page?
Page 28. Against for that reason, my lord, that order was passed. That is paragraph 1, my lord. Paragraph 1 and 2, my lord. That the petitioner is the owner of the property of 194.
That
And
is
my lord, the
exactly
opposite
what I
party
said.
number 1 and 2 has also purchased the property of 194.
So it's a private dispute
Yes,
between
my
the
lord.
parties.
Now that portion will be demarcated by us, man. There is no any such provision.
Why?
But if there is, my lord, any dispute, suppose, my lord, if there is any dispute relating to the, my lord, property in question, the BLR has got the power to demarcate the same upon payment of considered
That
fee.
direction was already given by the magistrate, isn't it? By the subdivisional magistrate.
I have submitted before the magistrate. Magistrate has passed the order, and my,
But the writ court cannot pass such an order.
no, that is.
You are aware, sir.
But only my
So I have to dismiss as not maintainable.
liberty to
Liberty to? You can withdraw if you want to.
wait.
But no liberty will be granted on the same cause of action. There is no cause of action at all.
Liberty to file, my lord, fresh, my lord, upon.
Same cause of action, no
No,
liberty.
that is that.
At all. That's a different cause of action. Affidavit of service. The petitioner seeks to withdraw the writ petition. Paragraph in view of the above, the writ petition being WP such and such is dismissed for non-prosecution. There shall, however, be no arrest to costs as a certified website code. It's a purely private dispute. Next. Yes, petition. Yeah, the petition.
Yes.
Lordship, I appear for the respondent number 1. Due to a technical snag, Your Lordship, my video was not turning on. I'm really sorry, Your Lordship. I apologize for this.
Who is this?
92, 692.
You're appearing for?
Respondent number 1, Union of India, Your Lordship.
Well,
4671.
Not all the parties are here.
No, I don't know.
My lord, 692 and 693 both may be taken up together. These are two writ petitions at the instance of occupants of a particular building which is adjacent to a national highway. The National Highway Authority issued a notice under section 26 of the Act stating that it is an unauthorized construction that is prevalent over there. Lordship, in WPA 11115, Lordship, these are persons who are occupants of the building who have not been served with any notice. In 1118, Lordship, that is the next matter, they are
all residents of the
same building. They are the petitioner.
For abundant precaution.
Pardon,
This is
Lordship?
for abundant precaution that you have come up with.
Yes, yes,
Even
because
without notice.
there are persons who have already received notice. The others, out of apprehension, they have come before your Lordship. Lordship, the persons who received notice, they appeared before the concerned authority, filed a written representation. As my lord knows, section 23(3) of the Act casts an incumbent duty upon the respondent authority that if an objection is thrown regarding the ownership of the central government, they have to hear out my objection first.
Yes.
Lordship, the first matter, that is 11115, Lordship, nothing has been done. Lordship is already hearing one matter where Mr. Oyon Banerjee is appearing. Lordship had previously, did they attack to just...
Similar matter.
It is a similar matter where the highway authority
Please serve a copy to them.
Copy আছে? My lord, I shall serve them. I shall serve them. Here, the notice itself was not in compliance. Lordship had
So
admitted.
this was issued to that apartment and not to any individual.
Yes, yes. Similar matter, Lordship, because there is default on part of the National Highway Authority in issuance of the notice itself.
So let
It
me
is
take up
on the self same road also, I am told.
second Tadinto. Second matter Tadinto. Where is the notice?
My lord, may kindly turn over to page
118.
135 and 136. These are two notices which have been handed over to my, has my lord got it? 135 and 136.
Yes.
These are two notices, both dated 29th of December 2023, addressed just to one Pradeep Kumar De. Lordship does not specify anything with regard to the property, what is the nature of illegality. Nothing is there on record, Lordship. Lordship, thereafter, if my lord turns over to page 137
This is the objection.
and page 142, my lord, these are the two objections which have already been filed. Lordship will see at the top of both the
They have not
pages.
been dealt with.
No. Because I am in occupation of those that particular building. All the petitioners who are there in the both the writ petitions, Lordship, I have annexed their title deeds. All are registered deeds by virtue of which they are in occupation of the. So, Lordship, without affording me an opportunity of hearing, Lordship, they could not have just issued and classified me as an unauthorized occupant with regard to the property.
Let us hear the
Lordship.
I think the National Highway is the answering this.
My lord, regarding the notice, my lord, my submissions, lordship, he are aware of this notice, my lord. Once, lordship, they raise the objections, lordship, they are aware of this notice.
Some of them, two of them.
My lord, here the Dibyendu Mahanto, my lordship, the Dibyendu Mahanto, my lordship.
The second writ petition, they have received the notice.
Lordship, the objection regarding lordship 142, my lord. That is their objection, lordship, raised by this lordship, the Dibyendu Mahato, lordship. That is the notice issued to 136.
Dibyendu Mahato and Pradeep Kumar De.
Yes.
They have filed objections.
My lord.
Have
My
you
lord,
dealt with the objections?
My lord, in this case, lordship, kindly allow me, lordship, one day accommodation, lordship. Tomorrow, lordship, I will.
But please see that no coercive action is taken.
Lordship, lordship, not recorded this, lordship, but
I will not record.
lordship, I will, lordship, only one day accommodation.
I accept it from the bar. I do not.
Lordship,
I will not record.
I'm grateful, lordship.
Come back next week. Take instructions and come back.
My lord.
Mr. Bandyopadhyay, anything to add?
I have nothing to say.
Because they are the answering respondents. Let them,
Yes, I am there.
let them take instructions and come back.
The first respondent, your lordship, is a pro forma respondent.
No notice issued on the petitioners of the first matter.
My lord, I will take instruction both of this, my lord.
Because the same building.
My lord.
Yes, anything to say, Miss Madam? The union
Yes,
of
your lordship, we are the pro forma respondents in this. The NHAI has to answer this, your lordship.
That's lordship out of the court, lordship. I am submitting lordship. Though lordship is out. The situation is lordship. Once you lordship give them a notice, lordship, they deny to accept the notice. And after lordship, once we serve the notice in the name of the apartment, lordship, now suddenly lordship they came and filed these applications, lordship.
You cannot serve
Lordship,
in the name of
the situation
apartment.
is lordship. The
Should be in
situation
the
is
name of
how
individual.
lordship. Yes, my lord. If they not came over, lordship came forward, and Suomoto lordship handed over the possession. So that is the difficulty we are facing in every time, lordship. That situation we are facing in every time, lordship. Because in this, this is lordship related to the Belguri Expressway. And we are already facing a contempt, lordship, this case, because the honorable division bench as well as the single bench of Devanshu Vashak, lordship, already monitoring us, already called the officers for removal of encroachment and suo motu basis, my lord. So we are facing in a very difficult way, lordship. Otherwise, lordship, if there is any kind of notice.
Why don't you file those documents before this? Let the other bench deal with it. If the honorable division bench is already dealing with this issue,
lordship, the dealing with this means, lordship, the one public interest litigation is going on, lordship, regarding this, and lordship, we are already facing a contempt in different court, lordship, because of this Belguri Expressway. Officers have been called.
It should be a legal notice in accordance with law.
My lord, the
there is a provision for objection. You have to consider the objections. It is only after you reject the objections that you can take the next step forward.
My lord, that is the difficulty, lordship, because the ground reality is, lordship, in different way, lordship, because I know regarding the pen and paper, Lordship, we should serve the copy to the individual person or the juristic person. The situation, Lordship, they came, not even, Lordship, they handed over their possessions, Lordship, even they denied to receive the notice, Lordship. Then being the officer, Lordship, what there because some contempt petition is going on.
By post. If there is a refusal, the endorsement will help you.
Lordship, the difficulty is, Lordship, how, because
for contemplate service by that.
yes, that I know, Lordship, because they were unable to know the address, Lordship. Once, Lordship, they suo moto read the objections, Lordship. Maybe, Lordship, because of this.
In this case, you are aware of the address. It's a building.
Now, Lordship, we are aware of this address. In another case,
through speed post, even if they refuse, there will be an endorsement of refusal, which amounts to due service.
My lord, the difficulties, Lordship, now, Lordship, we are aware of this. Yes, my lord. But, Lordship, now, Lordship, we are aware of this address. Before that, Lordship, we are not aware of this address of the inhabitants of that apartment.
You cannot expect the persons who are illegal.
No, my lord. No. Lordship, I am.
Go before you and say, see, I am
No,
illegal enclosure, take my land.
No, not at all, my lord.
That
Not
will
at
never
all.
happen.
No.
So it is the authority's responsibility.
Yes, my lord. The ground reality is different.
Inch from the law, you come before the court.
Yes, my lord. That's the difficulties,
I
Lordship.
understand the practical difficulty, but then
Practical difficulties, Lordship, because of this contempt, Lordship, we are facing a lot, Lordship, because of this now.
Our learned counsels for the parties. Learned counsel for the National Highways Authority of India seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 29th February, next week.
My lord, instead of 28th, my lord.
28th, same order, 693 per her.
Grateful, dear lord.
Order in both the matters. Pension matter is same heading here.
I am for the petition.
My lord, for the respondent, my lord, I am praying for 1 day accommodation, my lord. Miss Sushmita Shah Datta is appearing, my lord. She is Miss Sushmita Shah Datta, my lord. She has gone through the affected area in Sandeshkhali, my lord, with the ST commission.
Also a ground for agenda.
I am.
Oh, my lord.
I am also appearing in this matter, my lord.
Yes. For?
On behalf of the Union of India, for the Union of India. For the my lord, with Sushmita Shah Datta is appearing with you.
Sushmita Shah Datta.
So you are there, yes.
Yes.
Yes, my lord.
Adjournment on the ground of Sandeshkhali.
No.
My lord, this matter
It's appearing for the
First time, you know. But
state-
this requires to be different.
the district magistrate, have you served?
my lord, all the parties have been served, and this is, my lord,
Where is the service on the GP's office?
central government, my lords.
No. 6 and 7.
State service, state is not required in this matter.
Of course, they are parties, my lord. They need to answer very relevant facts, my lord. Facts which are in dispute.
Yes,
Where is, you're the petitioner?
I am for
Where
the
is
petition.
service on the state?
My lord, state is not party.
Respondent number 6 and 7.
6 and 7, my lord.
Respondent number 6 and 7. I am just checking at, my lord. Just a minute. Yes, I have served, my lord. If you are could take the trouble.
Where is the service on the GP's office?
DM office I have served, but DM is the custodian, and he is Mr. Pal is representing that person. My lord,
PLLRO.
yes, my lord. He is representing, my lord.
Request you to appear. Please serve a copy of the petition to Mr. They. I'll request him to appear in this matter for the state.
My lord, subject to your lordship counsel. If your lordship takes the trouble to hear for a minute, my lord. This is a matter, it is the third time. And my lord had the occasion to deal with the matter. In dealing with the contempt matter, it is matter relating to Enemy Property Act.
But you have implemented the state also as party?
A state, my lord, I have served the BLA.
You have served the state I have requested Mr. Dey to appear.
Yeah,
in this
I will
matter.
give a copy. I will.
Please serve a copy.
Yeah,
to
yeah,
me
yeah.
so that
Just
I can
in.
regularize his appointment.
Yes,
That's
yes,
all.
yes.
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 Yes. Now please make your submissions. What is
My
your
lord.
case?
But the issue, my lord, lordship kindly takes the trouble to see this short list of dates, if it might help your lordship.
My lord, may I interrupt at this stage, my lord? This is a matter which is in disputed question. It requires to be heard on after affidavits, my
My
lord.
lord, lordship, I have not spoken anything. He's asking for. What I submit,
well,
my lord,
let him submit.
entire document, already it has been adjudicated by the authority by my lord's direction. My lord called for the secretary, contempt was issued. Ultimately, with the intervention of my lord, it has been resolved. And in my petition, my lord, nothing to be affidavit because entire document has been. Just a minute, my lord, lordship kindly.
Asking for in this.
My lord,
this
I am challenging a decision of the Home Secretary related to Enemy Property Act. My lord, what happened, my lord? The order of challenge, my lord, order dated 25th August 2020 by the Joint Secretary. My lord, referred decision was taken pursuant to order of the Honorable High Court. My case was that this property cannot be covered under the Enemy Property Act because this property belonging to Indian citizens. Act says Pakistani national property can be treated as an enemy property. My case was it is completely a transaction made between Indian citizen. It is the Indian citizen's property. Therefore, it cannot be an enemy property. On that score, my lord, I initially moved the writ petition. Then this honorable court directed, making certain observation, which I will be showing, that has referred the matter for its adjudication under Section 18 before the Home Secretary. Then, my lord, I attended there. I personally attended twice, thrice. Matter could not be resolved. Ultimately, a contempt petition was taken out. My lord, this contempt petition ultimately disposed of your lordship by saying that you can attend virtually, and only after lordship can recall, only after my lord's intervention, it has been resolved. For the purpose of taking decision, they call for enemy properties, written submission, my written notes, whatever may be there, everything I have annexed. Therefore, my lord, why has submitted? Nothing to be added. The question for decision is whether a property belonging to Indian citizen, transaction made between Indian citizen, can be treated as an enemy property within the meaning of the Act. That is the precisely what I mean. What is their rejection? Rejection is peculiar. Rejection is this honorable court earlier decided that this property belonging to Indian citizen, but if they have got in unimpeachable document, then and then it can be interpreted. That I will show it, my lord. Basic thing, what they are relying upon, my lord, they are not disputing. They say initially there was a transaction, this property belonged to a certain person. In 51,
Let him make it clear who was the certain person. Who was that certain person? He was the president of Pakistan.
I will show him, because whatever they found, nothing to be added. I will rely on documents. Just let me finish, my lord. Once Sayyid Fateh Ali Midja, who happened to be the owner of the property. Then, my lord, in 1951, he bequeathed the property to his wife and two daughters. Then, my lord, in 1975, the donee, one of the daughter, transferred his interest to certain person. That person in 1988 ultimately sold the property to us. Then after that, we went to, for the purpose of mutation before the bailiwick, I came to know it has been recorded as enemy property. Then and then we raised the objection. We came up this honorable court. Honorable court's order I will be showing. Honorable court specifically observed that the property belonging to Indian citizen cannot be considered as enemy property. But however, as I told my lord, if there is any impeachable document they are possessing, then and then can say. What impeachable document they have showed me, I will be showing. According to that, the property which was transferred in my favor by the original owner, that person died before transfer, according to them. And for the same purpose, they relied on a book published from Pakistan. The book says in 1948 that person died. Our submission before the authority was that
you cannot rely on a book. It has to be authentic. It has to carry the month, date of it. It has to be supported by corroborated document of either death certificate or anything, nothing of any sort. But it is completely believed on a book published from Pakistan, saying that that person dead, therefore all transactions are not correct. We say, my lord, a person had been to the registered office, document was registered, it will be presumed to be a correct document unless rebutted by any other evidentiary document. For that, my lord, we relied upon Supreme Court decision. Supreme Court clearly says that a document is presumed to be correct if it is registered unless it is rebutted by any other document. What is the rebutted they got? They relied on a book, one page of a book published from Pakistan, which in the chronological table says that that person died in 1940. No mention of date, no mention of year, no supporting document on that score. Our second submission was that if a property is transferred, therefore, according to them, one of his son is Pakistani national. That's why his name would be his property. It is taken that it is his property. My case was that if the property is earlier transferred, there cannot be a devolution of interest on the person who is claiming to be owner, because it has been acted upon since 1951. And all the transactions were made. Series of transfer were made. But this is the case which my lord kindly take the trouble to see my list. One by one I'd be submitting. Just I am reading, my lord, if I allow me to read, my lord. Subject under challenge, order dated 25th August 2023 of Joint Secretary, Ministry of Home Affairs, Annexure P13, page 167 to 180 has been challenged. The referred decision was taken pursuant to order dated 2011-19 passed by the Honorable Court in WP number 996 of 2009 for determination of dispute under Section 18 of the Enemy Property Act 1968 as amended time to time. Page 60 is the operative part of the order. Petitioner case in short. Sayyid Fateh Ali Mirza was original recorded owner, where Milad I have shown page P1. Original owner by registered Hibanama dated 10/12/1952 gifted the land in favor of wife and two daughters, that is, I have annexed the referred. On 3/4/1973, one of the donee, namely Kazmi Bibi, transferred the property in favor of one Mehboob Ali. 30/12/1998, Mehboob Ali transferred the land to the petitioners annexure P4 such and such. In the attempt to record the name, it was learned that it is recorded as enemy property. LR record as such and such. In reply, application documents supplied to the petitioner to the effect that land is covered under enemy property by 1965, it should be notification. But as per civil law vested property, the subject lands are not included according to them, below. But the petitioner raised objection under Section 18 of the Enemy Property Act with specific case that the property owned by Indian citizen, all transferred by or between Indian citizens, such property cannot be considered as enemy property within the meaning of the Act. For non-consideration of such representation, Honorable Court was moved 996 of 2019. Pursuant to decision, no affidavit in opposition was filed by the respondent. 2/11/19, read disposed of, directing the Home Secretary Union of India take a decision on the representation of petitioner within the stipulated time. Pursuant to notice, petitioner represented the authority number of times for hearing. Since no decision was taken, contempt was filed. In the contempt proceeding, Honorable Court directed in terms of order dated to decide the proceeding. Ultimately, decision taken in terms of order dated rejecting the prayer of the petitioner in making decision with the submission or report of both the parties were called for and taken for its consideration. Written submission of custodian enemy property at page such and such. Exception to the report, petitioner through learned advocate appeared in hearing, submitted documents and written notes. The impugned order has been passed at page 122, para 6, operative part, basically on the ground Original owner, namely Sayyid Fateh Ali Mirza, died in 1948 before execution of Hibanama, dated 10/12/1952. It should be, my lord. It should be. As such, transfer made is valid, not valid. In arriving at the conclusion of the death of Sayyid Fateh Ali Mirza in 1948, the concerned authority solely relied upon the report of estate manager, which is based on publication in a book about the death of Sayyid Fateh Ali Mirza in 1948. Report of statement, all have seen. Basic argument of the petitioner before the authority was, which I will rely on, property belonging to Indian citizen, all transfer made by and between Indian citizens, such land cannot be included as enemy property within the meaning, it should be meaning of the Act as confirmed by the Honorable High Court. I will show High Court's decision, my lord. Regarding the fact of alleged death of Sayyid Fateh Ali Mirza, no reliance can be made on the publication on such a book having no evidentiary value. More so, such publication of book is not corroborated by a death certificate of the appropriate authority, and no reference was made regarding date and month of death. Willard, all transfers of land were made by registered instrument. Registration of a document carries presumptive value of valid document, and the authority failed to discharge its owners in proving duly registered document as void or invalid in the eye of law. No order passed on vesting of land. That I will show, my lord. Property of Indian citizen cannot be treated and vested as enemy property. Notification of vesting does not cover the referred land within its schedule. Impugned order passed without any consideration of the Honorable High Court. And I like to add one thing that is not written, my lord. That is my precisely my saying. If a property transferred in 1952, there cannot be any devolution of interest to any other party. It follows that unless the document is proved as invalid by any competent court of law. Admitted in 1951, as I have showed, my lord, the original transferred to his one wife and two daughters, and one daughter in turn transferred in 1973. Then we have acquired interest in 1994. This has been all by way of registered instrument. What I submit, my lord, what my learned friend said, no affidavit is required because of every document, what was there before the authority, I have not said a single word before that. If your lordship kindly hears it matter, these persons are so long fighting for the cause.
Please come back some other day.
Yes, any day subject to lordship. I can give me some time. I will just,
Yes.
I will not go beyond that.
Do you want to come back with a report or something?
No, my lord, I want to, my lord,
record.
I want to file an affidavit in opposition. Well, the basic issue is that person who he claims is the owner of the property, he is possibly the son of a person who was the president, who became the president of Pakistan. He could not have, my lord, these are facts which judicial notice can be taken.
Yes, yes.
Please
This
come
is
back
not
with a report. Affidavits are not required. I don't think will be required. Please come back with a report in the form of an affidavit.
very well, my lord, very well.
State is not necessary.
Not required.
Because, my lord, that is sufficient here.
Well, the state also has to give a report because ultimately because it was original report. Original report was by the DM, my lord. The state cannot.
I have given.
State cannot shirk responsibility, my lord.
अरे ना तुम्हारा तो ये भी तो ही आसो
A separate report. Regulation of subsidiary. Paragraph for learned counsel for the petitioners. Paragraph learned counsel for respondent numbers 1 to 5. You are 1 to 5.
1 to 5.
1 to 5 seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the heading motion on March 14th.
Some precedents, my lord, subject to lawsuit. Some precedents, because I want to dispose of matter, because these persons
all
are
matters are required to be disposed of. Sir, come back, let us see where it stands.
14.
If before your lordship starting lordship, that item number 4, original site matter lordship, that for cross examination, that we intimated them early, well advanced lordship, that their witness is also not here lordship. Today was fixed for the cross examination. Lordship may kindly fix any date on the in the next
Adjournments have been granted also.
lordship on 2 occasion lordship, that
Last 2 occasions adjournments, this is the third. Yes, he had called my advocate on record in the morning to inform that the witness should not be there. They would be praying for an adjournment.
next week lordship any day lordship.
Next Thursday, I was praying, my lord, this matter has been, my lord, continuing for a while. If lordship can accommodate us.
Next Thursday, I have a division bench. I don't think.
Lordship, then we have to wait. There is no other option.
7th March. Thursday
Seven-
after that.
7th March, yes, my lord. Lordship may keep it on 7th.
2nd March ওই matter টা
On prayer of the respondent, the matter is adjourned. 4 number. Paragraph, let the matter appear.
My lord, the other matter, there is another election petition where he is appearing. I am also appearing. That has been yesterday. They took adjournment there also. It's fixed 7th March at 3 p.m. So if lordship keeps this at 2 p.m., we can, my lord, be here.
Lordship.
As the first matter.
As the first matter. At least we can make some progress. And then, my lord, go there.
I'm not fixing the date, the time. Come. I'll fix it at as the first matter.
Grateful, my lord.
Grateful.
Let the matter appear under the same heading on 7th March. Kaushik, 7th March একটা note রাখো, এটা first matter হবে 7th March.
Grateful lordship.
Please be ready on the next occasion. Call. Yes.
My lord, I am appearing on behalf of the petitioner, your lordship. My lord, I am only seeking for 2 weeks time, your lordship.
Why?
My lord, certain instructions are needed from the client, your lordship. He is not in town.
My lord, he's not in town.
Not in town, your lordship.
Very well, since the petitioner.
My lord, only 2 weeks time.
Yes, but this, your lordship will recall, my lord, this is that matter where they are asking for an appointment of arbitrator under section 11, my lord, of relief and undertaking, my lord, temporary provisions, where they have already taken the money, my lord, on compensation, and now, my lord, they want a second appointment. Last occasion, my lord, your lordship was of the view, my lord, perhaps that is.
The period of compensation was in dispute.
Yes.
The petitioner says that it was granted for a particular period of time, and after that there has been no arbitral proceeding.
There has been no arbitral proceeding, but money has been given for the subsequent period.
I'll deal with it. They're asking for enhancement for the remaining periods.
Yes, by appointment of arbitrator, and that your lordship thought that perhaps it's not permissible, so your lordship directed them to take instruction whether this can be disposed of on the basis of the representation, my lord, that they have written to me. Then, my lord, your lordship will not have to decide.
Yes.
Now that is already a prayer B. So, my lord,
if they want to come back, they want to keep the matter alive,
yes. So, your
alive for
lordship,
some more time.
give it a short date, my lord, because
14th March.
Grateful, your lordship.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14th March 2024.
Grateful.
Next.
But I am for the petitioner in this matter.
My lord, we appear on behalf of the my lord state respondents.
Yes.
But there was a previous order, my lord. I am challenging, my lord, an arbitrary fixation of a rent by, my lord, the private respondent, West Bengal Khadi Board, in respect of a property. Yes.
Yes, serve করেছি।
Fully complete.
এটা কি আমরা করবো না তোরা এটা তো আলাদা ওদের
তোমাদের এটা নয়, তোমাদের এটা খাদি কোর্টের
They have their own sets of advocates.
Yes,
yes.
Because it is their property and, my lord, basically no relief. Tomorrow against no relief.
There is the service on Khadi.
Appearance to
Khadi
ঠিক
board also. They've received. Who appears generally for Khadi?
কোনো আইডিয়া আছে? জানো?
No.
Not aware.
No idea, my lord.
Because I believe they are the answering respondents.
Yes, my lord, because I am challenging, my lord, their arbitrary fixation of, my lord, the rent in respect of the property.
In their absence, if I take up the matter, I don't think it will serve your purpose.
My lord,
Why don't you issue a notice to the learned counsel? Because service is
But
made.
we do not know, my lord, who appears, but we can give a notice, my lord, directly to the party.
That has been done already. but
Yes,
then
that has
the
already been done.
absence, It's difficult, I think.
Yes,
It's not
but
served
there's also an urgency
Already
in the
very
sense, my lord, that they are asking for, my lord, the enhanced amount, my lord, from my client. But there was, my lord, a previous, my lord, the order passed by this court that, my lord, the rent in respect to the property is to be, my lord, fixed by the rent controller. As against that finding of this honorable court, my lord, the Khadi board went to the Supreme Court dismissed that. Thereafter, my lord, it went on, my lord, like that. When, my lord, there was an agreement between the parties, my client was paying 5,000 rupees, they were accepted. Lately, my lord, they said that we are going to enhance the rent. We agreed, saying that yes, we are agreeable to enhancement of 5 to 10%. Suddenly, my lord, on the basis of, my lord, a finding of, my lord, the LA collector in a LA case, my lord, that is in respect of, my lord, as I understand from a West Bengal Valuation Boards Act, my lord, a determination. My lord, they say that in respect of this property, 43,000 and odd is to be payable per month in place and state of 5,000. So, my lord, I am challenging that finding that first of all, you cannot go to the West Bengal Valuation Board to ascertain the rent when there was an order passed by this honorable court for fixation by a rent controller because it was treated to be a property covered under the West Bengal Premises Tenancy Act. And therefore, your demand is an illegal demand. This is the whole ambit of my, my lord, the case.
Will you just inform them and come back? Just a notice.
As your lordship pleases, blood, কবে করবি? Blood, your lordship will, blood, kindly
Come back next week.
blood, I have an urgency in the nature, blood, that they are asking for the money.
That's fine. Next
Lord.
Thursday.
Threatening মানে কি
Can you serve in these?
property will be sealed বলেছে কোথায় বলেছে but there's another blood aspect which my learned friend says that blood we have stated at paragraph blood page 12 paragraph 33 that blood there is a they are threatening blood to dispossess my client in the event I do not pay this amount as they have demanded.
Has to be done in accordance with law. They cannot just come and
That
tell you about.
I'm not, but that, for that blood I need an order from your lordship.
Next Thursday.
But
Just
anything,
intimate them and come back
but
so that I can
any
dispose it
dates
out.
before that?
Thursday, I take up original side matters on Thursday.
Only on Thursdays. But
Next
then kindly
Thursday
pass an order, my lord, indicating that they are absent and my lord, your lordship will take up the matter. Yes. I'm grateful.
Affidavit of service filed by the petitioner is taken on record. Petitioners. And none appears for the second
the respondent number
and third respondents despite service.
second and
Paragraph, the petitioners are directed to serve notice upon the second and third respondents, intimating the adjourned date. Paragraph, let the matter appear under the same heading on 29th
as your
February.
lordship. Smile. I'm grateful. But may it be in the position.
Service so that I can take up the matter, even
Yes.
in their absence.
No, may it retain the position, blood. Because
Which
this
is
is
the
the item number 1 almost.
It will.
Right.
Original side matters are not many, so don't worry.
I'm grateful.
Next.
May it please your lordship, my lord, your lordship recalls
Trust matter.
trust matter.
Yes.
In this matter, I am appearing on behalf of the respondent. I am led by Mr. Sandeep Ghosh.
It was adjourned on your prayer on
Yes,
the
yes,
last.
last
occasion. Yes. So today you're ready?
Mr. Ghosh
Yes,
is there.
sir. My lord, just to recapitulate, my lord, your lordship has been, my lord, shown, my lord, the copy of the trust deed. Now, strictly speaking, my lord, I have come up before your lordship, my lord, under section 74, seeking an appointment of a new trustee in place and instead of a trustee who was there has expired. Now, my lord, admitted position that from that branch from which, my lord, the trustee was there, no legal heirs are there who are otherwise entitled to be appointed as, my lord, a trustee. So, my lord, vis-a-vis this, my lord, I have also shown to your lordship section 73 before placing section 74, and I've said that there is an impracticability, my lord, in respect of appointment by, my lord, the Board of Trust So that is the reason why, my lord, I have come up before your lordship, my lord, under section 74, seeking, my lord, my appointment. Now, my lord, under section 74 itself, your lordship will find that if your lordship kindly takes, my lord, section 74 for once. আবার মোটা বই একটা পাতলা বই নিয়ে আয় বাবা। এই অত মোটা বই দিস।
I have the book, Trust Act.
Yes.
Yes.
74, your lordship will find that, has my lord got it, my lord?
Yes.
Whenever any such vacancy or disqualification occurs and it is found impracticable to appoint a new trustee under section 73, the beneficiary may. Now, my lord, admittedly, my lord, I am a beneficiary of the trust. No doubt about it. And there's no dispute with regard to such. Vis-a-vis this, my lord, your lordship kindly have a look at section 60 for once. Right to proper trustees. The beneficiary has a right, subject to the provision of the instrument of the trust, that the trust property shall be properly protected and held and administered by proper persons and by proper number of such persons. Now, my lord, pausing here for a moment, your lordship recalls that I have from the trust itself, the intention of the settler was it would always be 10%, not less than that. The trust deed also specifically states that within 30 days from the, my lord, a situation where a new trustee needs to be appointed, the board of trustees should, my lord, appoint. In case of, my lord, the other branches, it has to be appointed by election. In case of the branch of Govindolal Shil, my lord, in which, my lord, my lord, comes into effect, my lord, it is, my lord, through rotation. Now, my lord, from the opposition, though, my lord, I have taken a point that this opposition has been, my lord, affirmed by the manager, who is otherwise not entitled under law, my lord, to do so. But assuming for a moment, your lordship, my lord, can look into the affidavit in opposition. Your lordship will find one of, my lord, the ground which they have taken in his opposition is paragraph number 4. At the outset, I say that the said petition is misconceived and premature. No member of either group of the trust can claim himself for the appointment as a trustee without due discussion on the issue in the meeting of the board of trustees, meaning thereby nomination as a trustee cannot be at the choice of an individual. If any person from either group is aggrieved by the decision of the board of trustees in connection with an appointment, only then such aggrieved member can approach this honorable court for redressal of his grievance in accordance with the provision of the Indian Trust Act. My lord, so far as this, my lord, paragraph is concerned, to one aspect, my lord, redressal. Yes, of course, the right is there under section 73 and 74 itself. My lord, keeping in view of the other intention in respect of paragraph 4, such, my lord, intention is absolutely misconceived. Because there is no restriction in the trust deed that only then a beneficiary may approach before your lordship, my lord, for his or anyone else, my lord, appointment, number 1. Secondly, my lord, the trust deed specifically says that in this kind of situation, my lord, how and when a new trustee will be appointed. I have already placed, my lord, but, my lord, for my satisfaction and since, my lord, considerable time has passed, my lord, I will again place, my lord, the relevant portion.
I think it's page 19.
Page 19. Page 19. I'm grateful to your lordship.
The rotation shall commence with the eldest son. That is stated. So there are other members of this Govindalal's.
There are other members of the Govindolal Shield's branch, but what we are concerned over here is, my lord, the person who has expired, my lord. Your lordship, kindly have a look at, my lord, the genealogical table for once, page 108. Your lordship will find Jawaharlal, my lord, the legal heirs of Jawaharlal. Last is Darika and Omyo. Omyo Nath Sen has expired. My lord, page 108, right hand side, my lord. Has my lord got it, my lord?
That is Kanailal's branch you're showing.
No, Jawaharlal, my lord, from here, page 108.
Yes, Jawaharlal.
Yes, your lordship will find that there are no legal heirs of Darika and Omyo.
Yes.
So if there is no legal heirs of Darika and Omyo, it automatically goes back to the other branches by rotation, and that is, my lord, the trust deed. And in fact, my lord, this fact is also admitted by them in their opposition that there is no legal heirs of Omyo. So if there is no legal of Omyo, and if the trust deed, my lord, specifically directs, my lord, how the new trustee will appoint it, and it has to be done by 30 days. There is no impediment for, my lord, a beneficiary coming under section 74 if he is otherwise entitled, which I'll show, my lord, to your lordship.
You are Joyanto.
I am, my lord, Joyanto Lal Sheel. Your lordship will find my name as the legal heir of Maniklal. Maniklal is the third son of Govindolal. Now, vis-a-vis this, my lord, kindly have a look at paragraph 10 of their opposition.
So what about the other heirs of
My lord, they have to be eligible under the trust deed. My lord, if I say it is by rotation, it has to be by rotation, because under section 74, your lordship has
How
to
do you define rotation? How do you clarify?
from the branches. Kindly have a look, my lord, at the relevant portion of the trust deed, my lord, for once. Are Tara re Baba. I'll only place, my lord, the relevant portions. Paragraph 19, second paragraph, be it known that the trustees appointed shall duly carry out the directions contained in the said trust, and on the expiry of every 5 years, new trustees shall be appointed. And the newly nominated trustees shall, as trustees, remain in possession of the said properties vested with the rights of this deed of trust. Save and except the period when Srijukta Babu Krishna Lal Sheel shall remain a trustee, the total number of trustees shall not be more than 10% at other times. 3 persons from the family branch of late Pannalal Sheel, 4 persons from the family branch of Govindolal Sheel, and 3 persons from the family branch of Kanailal Sheel. So what we are concerned is, my lord, branches of Govindolal Sheel. It always has to be, my lord, 4 persons. The trustees shall be appointed by voting in the manner of election from out of the family branches of late Pannalal Sheel and late Kanailal Sheel. So my branch is, my lord, not, my lord, by election. Then, my lord, kindly have a trustees shall be appointed every 5 years by rotation from the family branch of Govindolal Sheel, and this rotation shall commence with the eldest son. So this, my lord, was the intention of the settler. It has to be the eldest son.
So the eldest son is Piarilal.
The eldest son, if your lordship sees, my lord, the genealogical table is, my lord, Piarilal is, my lord, the eldest son.
Yes.
His, my lord, legal heirs is already represented. He's there, my lord. He's continuing as a trustee. Brojolal's, my lord, is already there. So if Pierrelal's and Brojolal's legal heirs are there, then comes my lord Maniklal. আমি জানি আমি আসছি বলছি if Pierrelal's and Brojolal's my lord legal heirs my lord are there or my lord or not there my lord otherwise entitled to be a trustee, then comes my lord the legal heirs of Maniklal, to which my lord I belong as the eldest son. In fact, my lord, your lordship will find from the genealogical table that 7 except me, no one else is there. It is clear from the genealogical table which they have accepted. I'll show, my lord, from the opposition. There is no, my lord, contention raised. So, my lord, after the expiry of this period, my lord, let us take, my lord, assume, my lord, if my lord Omionath Sen would have been alive. After 5 years, automatically, my lord, the new board of trustees should have been there. So automatically, I was, my lord, to be appointed as a trustee. So if, my lord, the intention of the settler, which your lordship has to take into consideration, is there, my lord, to be my lord, the eldest son of that particular branch is to be appointed as a trustee, my lord. Automatically, my lord, I am, my lord, entitled to be appointed as a trustee.
By rotation, starting from the eldest son.
Starting from the eldest son.
Eldest, then second, third. I mean,
Yes.
that way. Yes.
So Pyarelal, Brojolal, everyone is there. From my branch, I am, my lord, the eldest.
From your branch, there is no existing trustee. Who is the fourth?
Fourth trustees is my lord Somnath, na? Goshtolal.
From Govindulal's branch, who are the four trustees? Three, in fact, now, because
My lord, I'll just indicate to your lordship, my lord. Your lordship will find, my lord, the name of the trustees are there. Goloklal Shil is there from the branch of Goshtolal. Your lordship will find,
Goloklal, yes.
yes, Goloklal is there. Somendra Lal Shil is there from the branch of Pyarilal. And Pushpen Lal Shil is there.
From the branch of Pyarilal, who is that?
Somendra Lal Shil.
Somendralal, yes.
Yes. Somendra's name will, your lordship will find at
Somendralal's
left.
sons.
Left. He is, my lord, the legal heir of Shoilendra Lal. And Somendra Lal Shil's name, sorry, Pushpen Lal Shil's is the legal heir of from the branch of as a reversionary right, my lord, from the branch of Brojolal. Somendra Lal, your lordship will find. Somendra Lal নামটা কোথায় রে?
No, Somendralal is there.
Oh, sorry. Pushpen is, my lord, the legal heir of Punno.
Where is his name?
My lord, Pyarelal. Sorry, Priolal. Priolal. Your lordship will find his name over here. As, my lord, the legal heir of
Priolal is there.
Yes. Priolal, his legal heirs are Promoto, Poshupati, Punno. Punno's legal heir is Pushpen, son. But Pushpen has been appointed as a trustee on the basis of a reversionary right of Brojolal. Because Brojolal's, my lord, there was a will. This order is there, my lord. My learned friend has annexed, my lord, this order in his opposition. No dispute with regard to such. So if all the branches, my lord, is covered, the branch left is, my lord, Maniklal's, and that is me. So under section 74, there is no dispute that I am not a beneficiary. Under section 74, in other words, my lord, taking into consideration the intention of the settler, I am otherwise eligible to be, my lord, as a trustee. Now, the question which lies over here is, my lord, the objection which my learned friend has taken, my lord, through the managers, are whether they are sustainable or not. My lord, to this, my lord, your lordship will find three aspects are covered, my lord. One, my lord, the manager says that it is the intention of the settler that has to be taken into consideration. And adding to that, he says that only upon qualification or nomination of a trustee, and if any of the beneficiaries, my lord, is prejudiced by such appointment, then only I can come. That is, my lord, not the law. To my humble and respectful submission. That is not the law because of the simple reason that the trust specifically says, my lord, on what condition and on what basis, my lord, a new trustee can be appointed.
What
Now,
prompted you to approach the court? Was
my lord, there
the
is
apprehension, or is there any specific steps
No.
taken by them?
no. My lord right has accrued on the date when my lord one of the trustees expired. Because within 30 days, the board was supposed to, my lord, appoint, my lord, a new trustee.
So did the board sit for appointment? For
We do
taking a
not know.
decision?
We do not know because your lordship will kindly takes, my lord, the opposition for once, my lord. My lord, before this, my lord, I'll just trouble your lordship, my lord, with two letters which I have written. Page 109 and page 111.
Yes.
This was first written on 2nd June 2023. Third March, my lord, the trustee has my lord, who was there, my lord, has expired. 2nd June 2023, my lord, in spite of my lord receiving my letter, no act, my lord, done by my lord the trustees. Number one, no response as such. Second letter, my lord, of in the month of July. Then again, my lord, no action.
In the first letter, you made out a completely new story.
In the first letter,
That the family branch of Maniklal Sheel is entitled now. Paragraph 4 of your first letter.
yes, my lord, I am, my lord. I am, my lord, from the branch of Maniklal
Maniklal.
Sheel. That is how, my lord, a new trustee has to be appointed.
You say you're the only male member eligible.
Yes. My son is there, but since I, my lord, seniority, it has to be by seniority. I am entitled. My lord, there is no, my lord, ground raised in, my lord, the opposition, which could, my lord, demonstrate before your lordship that any of the, my lord, facts or any of the, my lord, cause of action which I have come up before your lordship, my lord, has to be decided by evidence. Number one. Secondly, my lord, there is no denial of the fact that otherwise also I am not entitled to. There is no denial of the fact that the trustee who was there has expired. There is no denial of the fact that no new trustees has been appointed, irrespective of the fact that 30 days have expired. So, my lord, if these 4 points are taken together, the board of trustees has, my lord, lost, my lord, their right to elect anyone. In any event, my lord, section 73 is now impractical. The board of trustees doesn't have any power now.
You say due to expiry of 30 days.
Not only that, because section 73 itself, my lord, gives, my lord, the situation under which, my lord, the new trustees can be appointed.
Yes.
Those situations are not there. Impracticable. That is the reason why, my lord, section 74. Kindly have a look at, my lord, section 73 for once. may be appointed in his place by the person nominated for that purpose by the instrument of trust. My lord, impracticable, not practical. If there be no such person or no such person able and willing to act, the author of the trust, if he be alive, no authors, my lord, are left. So, my lord, this is the impracticable situation.
The next, or the surviving or continuing trustees.
The surviving or continuing trustee or trustee for the time being, or the last surviving and continuing trustee, or with the consent of the court, the returning trustee, if they all retire simultaneously, or with the consent of the last retiring trustee.
This is applicable.
This is applicable when, my lord? This is applicable when, my lord, the deed of trust is silent, my lord, on how, my lord, the appointment takes place. But when, my lord, the trust deed specifically states that it has to be appointed in a particular manner, the board of trustee has to, my lord, take into consideration that. Discretionary power upon the trustees is given only when the trust deed is, my lord, absolutely silent upon the appointment. This is the discretionary power given upon the trustees. But when the particular trust deed itself says that it has to be appointed in a mode and manner, my lord, which is specifically there, there is no discretion left upon the trustees or the surviving trustees, my lord.
And 74 gives you the liberty to approach the civil court for appointment.
Civil court having principal jurisdiction.
Yes.
That is this court.
No.
Yes. The trustees, my lord, office is situated within the jurisdiction of this honorable court. In any event, my lord, let us take, my lord, your lordship does not have jurisdiction. Was there any whisper, my lord, made in the opposition? Let us assume, my lord, your lordship is.
Principal civil court of original
Yes.
jurisdiction doesn't indicate the high court. It is the district court, principal district court having original
My lord,
jurisdiction.
my lord, may I say this, my lord? Say, for example, my lord, let us take this as a normal suit. My lord, in CPC also, your lordship is quite aware, my lord, the principal civil court. Now, my lord, if the particular trust properties, my lord, address is situated within, where do I go? Is within, my lord, the this honorable court's jurisdiction. Where do I go?
In that case, also, I think the principal court of original principal civil court of original jurisdiction is the district judge.
Your lordship is assuming jurisdiction. It kindly considers, my lord. Apply to a principal civil court of original jurisdiction. It's the original jurisdiction. As if it is by way of a suit. Original proceeding. As if by way of a suit, as in the nature of an original proceeding, to which it has to be filed. Place of swing.
I have my doubts. I don't think it can be the high court. Civil court, it's the principal, not the principal court, it's the principal.
My lord, kindly, your lordship will be satisfied if I kindly, my lord, place their, my lord, opposition, one, my lord, order.
Yes.
It starts at page 10. Your lordship will find civil appellate jurisdiction, original site.
Yes.
Same trust. Now, there is no dispute that your lordship doesn't have any jurisdiction. Cannot be. Because this is the, my lord, the principal civil court of original jurisdiction.
Very well, let us hear the respondents.
My lord, I have something more to add. So, my lord, this is with regard to the maintainability and my right, my lord, to be appointed as a new trustee. Now, the second aspect is, my lord, I have certain, my lord, judgments to show, before which, my lord, kindly have a look, my lord, at the opposition for once.
Yes.
Your lordship will find that this has been affirmed by the manager of the trust.
You have pointed this out on the earlier.
Yes,
debate.
but I want to show, my lord, the sections, my lord, the relevant sections for one. Lordship will kindly takes, my lord, section 47 for once. Trustee cannot delegate. Your lordship recalls, my lord, on the previous occasion, I have placed, my lord, the relevant portions from the trust deed to which, my lord, it says to what acts and conduct in the manner, my lord, a manager can do. Trustee cannot delegate. A trustee cannot delegate his office or any of his duties either to a court trustee or to a stranger unless the instrument of trust so provides or the delegation is in the regular course of business or the delegation is necessary or the beneficiary being competent to contract consents to the delegation. The explanation portion, your lordship will kindly consider the appointment of an attorney or proxy to do an act merely ministerial and involving no independent discretion is not a delegation within the meaning of this section. So this is limited to the extent of a ministerial job, nothing more, until and unless, my lord, the trust deed specifically states so. Now, my lord, to this, my lord, I need to place, my lord, 4 judgments. I'll trouble your lordship will, my lord, with 4 judgments. First of all, my lord, আমার judgment গুলো কোথায় রে? Oh, এখানে. First of all, there's a judgment of Bombay High Court. No? Reported in 2000 volume 2 Maharashtra Law Journal, page 341. This is in respect of, my lord, the powers of section 74. Your lordship will find from this judgment that until and unless there is a contentious cause raised, meaning thereby, my lord, evidence is necessary, section 74 can be, my lord, allowed by this court. My lord, I'll start by placing from paragraph 8.
Yes.
Copy আছে? না না এসসিসি অনলাইন এসসিসি রে বলে দিচ্ছি 1999 এসসিসি অনলাইন বম্বে 499. Lordship will kindly take, my lord, from paragraph 8.
Yes.
We then have 2 relevant sections on which much stress has been laid by both the parties with section 73 and 74. Under section 73, whenever any person appointed a trustee disclaims or any trustee is either original or substituted dies or has for a continuous period of 6 months being absent from India or leaves India for the purpose of residing abroad or is declared as insolvent or desires to be discharged from the trust or refuses to become, in the opinion of a principal civil court of trustee, may be appointed in place of a person nominated for the purpose of the instrument of trust, if any or in the manner provided in surplus B. Under section 74, whenever any such vacancy or disqualification occurs and it is found impracticable to appoint a new trustee, under section 73, the beneficiary may, without instituting a suit, apply by petition to a principal civil court of original jurisdiction for the appointment of trustee or a new trustee, and the court may appoint a trustee or a new trustee accordingly. Therefore, section 70, 71, 73, and 74 provide for a situation when a new trustee vacates his office and the manner of appointment of a trustee in the place of the trustee who dies or is discharged from office. The question, therefore, is what is the scope and extent of section 74 of the Indian Trust? If section 74, read in its pristine form, would contemplate that a vacancy or disqualification occurs and it is found impracticable to appoint a new trustee under section 73, the beneficiary can move before principal civil court of original jurisdiction to appoint a trustee. Therefore, section 74 springs into action if an appointment is found to be impracticable under section 73. Section 73, as pointed out earlier, provides for various situations when a trustee can be appointed. I may briefly set out hereunder. Milord, these were, Milord, the relevant portions of section 73 is set out, Milord. Then, Milord, paragraph 11. Therefore, it is apparent that a vacancy must arise in order to enable the person set out in clause B of section 73 to appoint a new trustee. It is only in the event where it is found impracticable to appoint a new trustee under section 73, the beneficiary can move the civil court having the original jurisdiction to fill in the vacancy. Milord, kindly, Milord, consider the word used is civil court having original jurisdiction. So, Milord, in case of a normal suit, if this honorable court has jurisdiction otherwise and not barred under section 9, Milord, of the CPC, of course, this is a principal civil court, Milord. In the instant case, this court being the principal civil court of original jurisdiction, which has jurisdiction. Now, kindly, Milord, turns over, Milord, to paragraph 27 onwards. At page 350, starts from page 350.
Yes.
Therefore, applying the above test, the contention may now be decided. At this stage, I may point out that looking at the language of section 73 and 74, it is not possible to accept the view taken by the division bench of Allahabad High Court. On the contrary, I would prefer the view taken by the division bench of this, though an obited, but accepted by the Saurashtra High Court as also by the division bench of the Sindh High Court. I say, more specifically bearing in mind that while interpreting this section, it must be remembered that in some areas of the court may also exercise its equity jurisdiction. The English principle followed is that in the contentious matter, section 74 cannot be invoked and the party will have to be relegated to a suit. Now, this is the test. Now, Milord, kindly takes, Milord, from next page, the appointment under section. The appointment under section 73 can be made in the event a vacancy arises or a principal civil court of original jurisdiction holds that the person is unfit or personally incapable to act in the trust. Milord, this is one of the situations which my learned friend Milord has taken this point in his opposition. This is one of the situations, but not the only situation. Who is to decide that a vacancy has arisen? The trustee cannot decide until in the appointment under section vacancy if there is a dispute. Can it then be said that as it is impracticable to make appointments under section 73 and therefore appointments are to be made under section 74? Also, if the court opines that a vacancy has arisen, then an appointment can be made by the person named in the trust. This opinion in section 73 or appointment in section 74 if there is a vacancy should be read with section 60. Sections in an act must be read harmoniously. Milord, I have also shown, Milord, section 60. The intent of the legislature must be given effect to. The present act is a pre-independence act. There is a similar act in England which, with similar provision which has been referred to in the judgment of the division bench of this court and of Sindh High Court. It therefore will be safe to accept the interpretation bearing in mind that this court can also exercise equity jurisdiction. Having said so, the test can now be applied. Then, Milord, kindly, Milord, ignore, Milord, 3 lines. Kindly takes, Milord, the court therefore will have to examine.
Yes.
As to whether in fact the allegation as set out in paragraph 2 are supposed to be by material after evidence has been laid. So, Milord, this is, Milord, the actual test. Has there anything being raised by, Milord, the manager, which will, Milord, suggest that evidence is required, Milord, for the purpose of determining the real issue? There is none. And in any event, Milord, this opposition cannot be taken into consideration. That's number one aspect. So, Milord, having said so, Milord, the question now comes into effect, my lord, whether the manager can, my lord, ultimately affirm this. 1979 ta dao. My lord, before this, my lord, one more judgment of our honorable court, my lord. This is reported in 2002, volume 1, Calcutta Law Times. I'm just
My lord, possibly my land friend will continue for some more time. My lord, I have a matter fixed before the division at 3 p.m. My lord,
So let's continue till 3 p.m.
yes, till 3 p.m. I'll submit on the next day.
Yes.
Now, my lord, this is, my lord, your lordship will kindly takes, my lord, paragraph 5. In both the sections, my lord, my lord, ignoring 4 lines, my lord, from the top of paragraph 5. In both the section, any trustee without instituting the suit can apply to the court having appropriate jurisdiction mentioned therein for getting any direction in respect of management or administration of the trust property. Therefore, these are summary procedures under section 73 and 74 are neither. This is basically, my lord, what I am on, my lord. This is a summary procedure. So, my lord, anything which requires evidence, of course, suit. If that is not so, my lord, a person objecting doesn't have, my lord, anything, my lord, any ground to object. Now, my lord, only one thing, my lord, I must show to your lordship. I'm very sorry, my lord, I should have placed, my lord, at that time. Your lordship kindly takes, my lord, the opposition for once, my lord.
Yes.
Your lordship will find, my lord, the order which I have shown, my lord, of our honorable court, page 10.
Yes.
Now, by this order, they are trying to, my lord, make out a case that the appointment procedure laid down over here will apply in respect of, my lord, the other branches. That is not so. Kindly takes, my lord, page 10, it's, my lord, starts.
This is with regard to the branch of?
Yes, that is clear, my lord. Paragraph 30.
Paragraph?
Sorry, page 30, my lord.
30.
Page 30. This was, my lord, in respect of Brojolal. And, my lord, the honorable division bench has specifically made it clear that this appointment procedure or anything would apply only to the branch of Brojolal.
Brojolal comes under
Govindolal, second branch. My lord, the second son of Govindolal. My lord, I have shown Pushpen, my lord, as one of the trustee, and I've said, my lord, as a reversioner, my lord, he is getting.
Yes, yes.
My lord, this, my lord, was, my lord, the situation in which. So, Brojolal has no, my lord, your lordship will find from the genealogical table, there are no legal heirs. It's only on the basis of a reversionary right, or, my lord, in case of a will, which was prepared by Brojolal, my lord, the trustees are appointed. And kindly have a look, my lord, at page 30. With regard to the other group, we do not wish to make any comment since there was no dispute with regard to the selection of other members. We abundantly make it clear our decision would relate to Brojolal group only, and the same would not be binding on the other branches.
Yes.
Now, my lord, with regard to the fact that whether if the trustee doesn't, my lord, say anything about, my lord, the manager's power, manager of the, my lord, trustee, can he, my lord, affirm this affidavit, my lord? Because this I've shown, my lord, the explanation portion.
You say that it is more than a ministerial.
He's taking an independent decision.
Is he?
Yes, he is, my lord. He is affirming this instant affidavit
Being
that
authorized by the trust. He is
can
authorized by the trust.
no, he might have been authorized by the trust. But kindly have a look, my lord, at the paragraph 1. I'm the manager of such and such, having office such and such, duly authorized to affidavit, and have made myself well acquainted with the facts and circumstances of the instant case. So this is his personal knowledge. Number one. Secondly, the affirmation of an affidavit is not a ministerial job. Milord, for example, kindly takes Milord for once, Milord, section 47. Milord, I am troubling your lordship, Milord, but
Not. Yes, section 47.
yes. Illustration B. Kindly have a look. WhatsApp করে যাচ্ছে কেন? দে. Kindly takes into consideration A is a trustee of certain property with power to sell the same. A may employ an auctioneer to effect the sale. That's it. But the auctioneer power is effecting the sale, not Milord deciding at what price it will be sold, to whom it will be sold, on which date it will be Milord done.
An auctioneer is different from a manager.
Milord,
They are not synonymous.
same power, Milord. That is, Milord, the delegation power. Manager is Milord, a person, Milord, appointed either, Milord, by the trustee or under the trust deed, Milord.
Why don't we deal with it on merits?
I'm sorry,
This
Milord.
is technical. You're on a technical issue. Why don't we deal with the matter on merits?
Merits.
Which you have already
but this is, Milord, but this is also, Milord, something, Milord, directly connected with the merits, in as much as, Milord, the stand which the manager has taken is contrary to the trust deed. Milord, he says that the trust deed has to
That
be.
is again on merits. That we'll discuss. That
And
we'll
Milord,
consider.
the Supreme Court judgment says so. আরে দাঁড়া, একটা পয়েন্ট বলছি তো, অদ্ভুত ব্যাপার।
Where is the judgment of the Supreme Court?
I'm placing before your lordship, Milord.
I think you need to continue on the next day, please, because
Kindly excuse for today.
Milord, may I just
Any day in the next week, any day.
he's restless. He has to go to the other court, I think.
3 matters are there at 3 p.m.
Advocate on record is there. May I just finish it, Milord, so that on the next date, Milord, he can.
But I have no.
Is it difficult for you?
My junior is there.
So will he complete today? So
Okay.
that- yes.
Okay. Now kindly allow me to leave. Milord.
Yes, sure.
I am-
Yes. That will be better if you can complete today. Yes.
I want to. আমি বলে দেবো আপনাকে। So first is 1979. ওটা দিয়েছি আমারটা কোথায়? First is 1979, volume 4, SCC, page 602. Milord, this is on the basis of a delegation power of the trustees. Lordship will kindly takes, Milord, from pages, from paragraph 26 onwards. The law governing the execution of trust is well settled. Have my lord got it?
Page
Milord?
26 on.
Paragraph 26 onward, at page 611.
Yes.
The law governing the execution of trust is well settled. In the case of a private trust, where there are more trustees than one, all must join in the execution of the trust. The concurrence of all is in general necessary in the execution of the trust. The concurrence of all is necessary in a transaction affecting the trust property, and a majority cannot bind the trust estate. In order to bind the trust estate, the act must be the act of all. They constitute one body in the eye of law, and all must act together. This is, of course, subject to any express direction given by the settler. Then, Milord, certain Milord judgments have been referred. Kindly takes, my lord, from paragraph 27 onwards. Next. It follows as a necessary corollary that where there are several trustees, they must act unanimously in making a sale or a contract of sale, unless it is provided otherwise by the terms of the deal. In exercising the power of sale, as in the exercise of other powers of a trustee, cannot therefore properly delegate the performance of the acts which he ought personally to perform. This is something, my lord, the trustees has to be performed personally. There are exceptions. I will also place, my lord, another judgment which takes into consideration the exceptions. If this opposition, my lord, would have been, my lord, affirmed by one of the trustee on behalf of the others, of course, my lord, legitimate. But this has been affirmed by one of the manager. The manager's power under the trust deed is absolutely limited. Is only for management of the trust affairs, nothing else. Although a trustee may listen to the opinions and wishes of others, he must exercise his own judgment. Thus, a trustee for sale of property cannot leave the whole conduct of a sale to his co-trustees. Whole conduct of a sale. The reason for this that the settlor has entrusted the trust property and its management to all the trustees, and the beneficiaries are entitled to the benefit of their collective wisdom and experience. Then, my lord, kindly ignores paragraph 28-29. Kindly takes, my lord, paragraph 30. In the present case, as the High Court rightly observed, there is no such clause in the trust deed authorizing the execution of the trust to be carried out not by all, but by one or more or majority of the trustees. In the absence of such a specific provision, the general law envisaged in section 48 of the Act would govern the rights of the parties. We are accordingly of the opinion that the alleged contract of sale entered into by the 4 trustees were not binding and of no legal effect. Kindly takes, my lord, paragraph 31. These are the exceptions. 31 and 32. My lord, 47 is set out. Kindly takes, my lord, paragraph 32. Section 48 is a corollary of section 47. For if the trustee cannot delegate their duties, it follows that they must all personally perform those duties and not appoint one of themselves to manage the business of the trust. For the settlor has trusted all his trustees, and it behoves each and every one of them to exercise his individual judgment and discretion on every matter, and not blindly to leave any question to his co-trustee or co-trustee. So this is very important, my lord. Though a technical point, but for the trust matter, because it is ultimately the intention of the settlor which your lordship has to decide. So, my lord, the next judgment which I want to place is 2005 volume 1 SCC page 172 at paragraph 29.
Yes.
My lord, the paragraph itself begins that therefore, although a rule, trustee must execute the duties of their office jointly, this general principle is subject to the following exceptions. Then, my lord, these exceptions are given as similar to section 47. So, my lord, the situations which are, my lord, enumerated in section 47 are, my lord, exceptions to the general rule. So, my lord, my learned friend had to satisfy that either, my lord, from the trust deed, he had to, my lord, point out that the settlor has given, my lord, the manager to, my lord, affirm this affidavit. Number 1.
No, Lord, that bench will not sit, my lord.
Number 1. Secondly, he had to, my lord, rather he will now have to satisfy your lordship that this is not a ministerial job, or rather it's only a ministerial job. which in my humble and respectful submission, my lord, this is an affidavit in opposition. Last thing, my lord. Kindly takes, my lord. What is troubling your lordship is, my lord, principal civil court of district. This is, your lordship will find section 2, subsection 4, district. Means the local limits of the jurisdiction of prince. Has my lord got it, my lord?
Yes.
District means the local limits of the jurisdiction of a principal civil court of original jurisdiction and includes
Section 2,
4, subsection 4. District
yes.
means the local limits of the jurisdiction of a principal civil court of original jurisdiction, hereinafter called a district court, and includes the local limits of ordinary original civil jurisdiction of high court.
So it's
This is
inclusive.
not a point, my lord. And in any event, my lord, let us assume, my lord, for the time being, that this is not a competent court. Has this point been taken at the threshold?
No, it has not been taken. It struck me actually. It was
So
not
that
taken by
this is
the.
only for your lordship's satisfaction. So, my lord, these are my respectful submissions, my lord, before your lordship, that section 74 applies over here squarely. I am otherwise entitled to be appointed as a new trustee because they have not only failed to appoint within 30 days as enumerated in the trust deed, but have not taken any steps otherwise. Management of the trust is, my lord, a joint action of the trustees. Intention of the settler is 10%, which now is 9. And, my lord, there is nothing on record which would suggest that evidence has to be taken in order to decide, my lord, the controversy in issue or the factual aspect in issue.
That's all.
No, ওটা তো এটা আমাদের ঠিক আছে.
That's all your submission.
That's great.
Will you make your submission on the
Yes.
next date?
I shall try as his comments.
When can you come back?
My lord, I have finished.
Yes,
done it.
he'll commence on the next date.
I leave it
As your lordship pleases. The next week, any day, if your lordship fixes, I can start.
Next week, I have a division bench. It will be, I do not know
Oh,
how,
acha, acha.
how long it will continue.
আচ্ছা।
Next week, আছে না original side division bench? আমার মনে হচ্ছে next, হ্যাঁ, আমার যতদূর মনে পড়ছে 29 তারিখে আছে। হুম 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 হুম।
At a criminal action. Criminal action.
Will you come back on 7th?
7th.
Week after that.
7th, কি problem? 7th, Thursday.
7th March?
Yes, yes.
For learned counsel for the petitioner, paragraph, let the matter appear under the same heading on 7th March 2024. এটা নিয়ে নিও। নিয়ে নিও।
কিছুই হলো না।
Around 7.
7, yes.
And fairly on the top, my lord.
It will retain its
That's
position.
all, the entire list is called.
All matters are called up.
Great.